This is an evidentiary hearing before the Indiana Utility Regulatory Commission and a cause document before the Commission as cause number 46038, captioned as Petition of Duke Energy Indiana, LLC, pursuant to Indiana Code Sections 8-1-2-42.7 and 8-1-2-61 for 1, authority to modify its rates and charges for electric utility service through a multi-step rate implementation of new rates and charges using a forecasted test period. 2, approval of new schedules of rates and charges, general rules and regulations and riders. 3, approval of revised electric depreciation rates applicable to its electric plant in service, and approval of regulatory asset treatment upon retirement of the company's last coal-fired steam generation plant. 4, approval of an adjustment to the company's FAC rider to track coal inventory balances. And 5, approval of necessary and appropriate accounting relief, including authority to A, defer to a regulatory asset expenses associated with the Edwardsport carbon capture and sequestration study. B, defer to a regulatory asset cost incurred to achieve organizational savings. And C, defer to a regulatory asset or liability as applicable, all calculated all calculated income tax differences resulting from future changes in income tax rates. Notice of the time and place of the hearing was given as provided by law by publication in Marion County through the Indianapolis Star on July 10th, 2024, and in Hamilton County through the Hamilton County Reporter on July 15th, 2024, and also through the Times of Noblesville on July 10th, 2024. These are newspapers of general circulation, and these publications were made at least 10 days prior to the date of the evidentiary hearing. Excuse me, counsel. Let's go off the record. Let's go back on the record. These proofs of publication of the notices have been received by the Commission and are now incorporated into the record of this cause by reference and placed in the official files of the Commission. Notice has also been given to the Indiana Office of Utility Consumer Counselor and other interested parties. We would have appearances, please. First, on behalf of petitioner.
Thank you, Your Honor. On behalf of petitioner Duke Energy Indiana, LLC, please accept the appearances of Beth Hennigan, Andrew Wells, Leanne Steffes, and with the law firm of Barnes & Thornburg, LLP, Nicholas Kyle, Hillary Close, Lauren Box, and Lauren Aguilar.
And on behalf of Block, LLC.
Thank you, Your Honor. Appearing on behalf of Intervenor Block, LLC, Joseph Rampala of the law firm Lewis Kappas, 1 American Square, Suite 2500, Indianapolis, Indiana.
On behalf of Citizens Action Coalition of Indiana.
Thank you, Your Honor. Please accept the appearance of Jennifer Washburn.
City of Westfield.
Good morning, Your Honor. Appearing on behalf of the City of Westfield, Nikki Schultz of the law firm Bose, McKinney & Evans, Indianapolis.
On behalf of Duke Industrial Group.
Thank you, Your Honor. On behalf of the Industrial Group, Todd Richardson and Aaron Schmoll of the law firm Lewis & Kappas here in Indianapolis.
The Kroger Company.
Good morning, Your Honor. Appearing on behalf of the Kroger Company, Kurt Boehm and Jody Kyler Cohn of Cincinnati, Ohio, and John Cook of Franklin, Indiana.
Nucor Steel, Indiana.
Thank you, Your Honor. Appearing on behalf of Intervenor, Nucor Steel, Indiana, a division of Nucor Corporation, Ann Becker with the law firm Lewis Kappas, 1 American Square, Suite 2500, Indianapolis, Indiana.
River Ridge Development Authority.
Thank you, Your Honor. On behalf of River Ridge Development Authority, River Ridge Property Owners Association, and Rolls-Royce Corporation, please accept the appearance of Christina Kern-Wheeler and Nikki Gray Schultz of the law firm Bose, McKinney & Evans in Indianapolis.
On behalf of Sierra Club.
Joshua Smith on behalf of Sierra Club. Thank you very much.
Thank you, Mr. Smith. Steel Dynamics.
Thank you, Your Honor. Appearing on behalf of Intervenor Steel Dynamics, Inc., please accept the appearance of Clayton C. Miller with Clayton Miller Law, P.C., Indianapolis, Indiana.
Wabash Valley Power Association.
On behalf of Wabash Valley Power Association, please accept the appearance of Robin Zicola with the law firm Parr Ritchie in Indianapolis. Thank you.
Walmart Incorporated.
Yes, good morning, Your Honor. Barry Naum, appearing on behalf of Walmart Incorporated from the law firm of Spillman, Thomas & Battle in Mechanicsburg, Pennsylvania, appearing pro hoc vice in accordance with the order issued by Your Honor yesterday.
Indiana Office of Utility Consumer Counselor.
Thank you, Your Honor. Appearing for the public from the Indiana Office of Utility Consumer Counselor, Tom Harper, Adam Cashin, and Lorraine Hitz.
Thank you, Mr. Harper. There are a couple of matters that counsel and I discussed before going on the record today. First, Mr. Rampala and Ms. Zacola indicated that there are portions during the evidentiary hearing when they and their clients have decided not to have them present for today's hearing. Certainly that would be, after speaking with counsel, that there be no objections to that, those requests are granted. Additionally, it's my understanding that procedurally, petitioner will admit its pre-filed testimony and exhibits en masse, after which we'll do that for each subsequent party. But for the Sierra Club, who will be admitting their exhibits early next week, I believe. And I think the OECC had two exhibits that they will admit next week as well. Anything further before we begin the substantive portion of the evidentiary hearing? Okay, Mr. Wells, when you're ready, please proceed.
Thank you, Your Honor. At this time, petitioner will move to admit petitioner's exhibit number 1, direct testimony of Stan C. Pinniger, sponsoring attachments 1A, 1B, and 1C. Petitioner's exhibit 2, the direct testimony of Joel T. Rutledge, with attachments 2A through 2D. Petitioner's exhibit number 2C, the confidential portions of the direct testimony of Joel T. Rutledge. Petitioner's exhibit 3, the direct testimony of Krista L. Graft, sponsoring attachments 3A and 3B. Petitioner's exhibit number 4, direct testimony of Suzanne E. Sieferman, sponsoring attachments 4A through 4F. Petitioner's exhibit number 5, direct testimony of Kathy C. Lilly, sponsoring attachments 5A through 5L. Petitioner's exhibit number 6, direct testimony of Maria T. Diaz. Petitioner's exhibit number 6C, the confidential portions of direct testimony of Maria T. Diaz, with confidential attachments 6A through 6G. Petitioner's exhibit number 7, direct testimony of Roger A. Flick, sponsoring attachments 7A through 7I. Petitioner's exhibit number 8, direct testimony of Vicki Rimmel, sponsoring attachments 8A through 8C. Petitioner's exhibit number 9, the direct testimony of Christopher R. Bauer. Petitioner's exhibit number 10, the direct testimony of Adrian M. McKenzie, sponsoring attachments 10A through 10L. Petitioner's exhibit number 11, direct testimony of Jeffrey T. Kopp, sponsoring attachment 11A. Petitioner's exhibit number 12, the direct testimony of John J. Spanos, sponsoring attachments 12A and 12B. Petitioner's exhibit number 13, the direct testimony of Sean B. Riley. Petitioner's exhibit number 14, the direct testimony of Rebecca E. Buck, sponsoring attachments 14A through 14F. Petitioner's exhibit number 15, the direct testimony of John R. Paniza. Petitioner's exhibit number 16, the direct testimony of Shannon A. Caldwell, sponsoring attachments 16A. Petitioner's exhibit number 16C, confidential attachments 16B SAC and 16C SAC to the direct testimony of Shannon A. Caldwell. Petitioner's exhibit number 17, the direct testimony of William C. Bill Luke, sponsoring attachments 17A and 17B. Petitioner's exhibit number 18, the direct testimony of Peter Heflisch. Petitioner's exhibit number 19, direct testimony of Timothy S. Hill, sponsoring attachments 19A through 19F. Petitioner's exhibit number 19C, confidential portions of the direct testimony of Timothy S. Hill. Petitioners Exhibit Number 20, the direct testimony of John D. Suez. Petitioners Exhibit Number 20C, the confidential portions of direct testimony of John D. Suez. Petitioners Exhibit Number 21, the direct testimony of John A. Verderami. Petitioners Exhibit Number 21C, the confidential portions of the direct testimony of John A. Verderami. Petitioners Exhibit Number 22, the direct testimony of Timothy A. Abbott, sponsoring attachments 22A and 22B. Petitioners Exhibit Number 22C, the confidential portions of the direct testimony of Timothy A. Abbott, confidential attachments 22C, 22D, and 22E to the direct testimony of Timothy A. Abbott. Petitioners Exhibit Number 23, the direct testimony of Brian T. Liggett, sponsoring attachments 23A and 23B. Petitioners Exhibit Number 23C, which is a confidential attachment 23A to the direct testimony of Brian T. Liggett. Petitioners Exhibit 24, the direct testimony of Jacob S. Colley, sponsoring attachment 24A. Petitioners Exhibit Number 25, the PDF version of Petitioners Exhibit Number 26, revenue requirement model. Petitioners Exhibit Number 26, the revenue requirement model, an Excel version. The pre-filed rebuttal evidence now. Petitioners Exhibit Number 28, the rebuttal testimony of Stan C. Pinniger, sponsoring attachments 28A. The Petitioners Exhibit Number 29, the rebuttal testimony of Krista L. Graft. Petitioners Exhibit Number 30, the rebuttal testimony of Suzanne E. Sieferman. Petitioners Exhibit Number 30C, the confidential portions of the rebuttal testimony of Suzanne E. Sieferman. Petitioners Exhibit Number 31, the rebuttal testimony of Catherine C. Lilly. Petitioners Exhibit Number 32, the rebuttal testimony of Maria T. Diaz. Petitioners Exhibit Number 32, Petitioners Exhibit Number 32C, the confidential portions of rebuttal testimony of Maria T. Diaz, which includes confidential attachments 32A and 32B to the rebuttal testimony of Maria T. Diaz. Petitioners Exhibit Number 33, rebuttal testimony of Roger A. Flick, which includes attachments 33A through 33B. Petitioners Exhibit Number 33C, confidential portions of the rebuttal testimony of Roger A. Flick. Petitioners Exhibit Number 34, the rebuttal testimony of Vicki Rimmel, inclusive of attachment 34A. Petitioners Exhibit Number 35, which is a rebuttal testimony of Adrian M. McKenzie, which includes attachments 35A to 35D. Petitioners Exhibit Number 36, the rebuttal testimony of Jeffrey T. Kopp. Petitioners Exhibit Number 37, the rebuttal testimony of John J. Spanos, which includes attachments 37A through attachment 37B. Petitioners Exhibit Number 38, the rebuttal testimony of Sean P. Riley. Petitioners Exhibit Number 39, the rebuttal testimony of Shannon A. Caldwell. Petitioners Exhibit Number 40, the rebuttal testimony of William C. Bill Luke. Petitioners Exhibit Number 41, the rebuttal testimony of Peter Hayflish. Petitioners Exhibit Number 42, the rebuttal testimony of Timothy S. Hill. Petitioners Exhibit Number 42C, the confidential portions of rebuttal testimony of Timothy S. Hill, including attachment 42A. Petitioners Exhibit Number 43, the rebuttal testimony of John D. Suez. Petitioners Exhibit Number 43C, the confidential portions of the rebuttal testimony of John D. Suez. Petitioners Exhibit 44, the rebuttal testimony of John A. Verderami. Petitioners Exhibit Number 45, the rebuttal testimony of Jacob S. Colley, which includes attachment 45A, which was subject to a revision on page 21, line 12, and all council has been made aware of that.
Would you indicate what that correction was, please?
The word all on line 12 was revised to significant portion.
Thank you, Counsel. Mr. Wells, please proceed.
Thank you, Your Honor. Petitioner Exhibit Number 46, the rebuttal testimony of Christopher R. Bauer, which includes attachments 46A through 46E. Petitioner's Exhibit Number 47, the rebuttal testimony of Patrick O'Connor. Petitioner's Exhibit Number 48, the PDF version of Petitioner's Exhibit Number 49, updated revenue requirement model. Excuse me, Your Honor, I think I mispronounced that one. It was Petitioner's Exhibit Number 48, the PDF version of Petitioner's Exhibit Number 49, the updated revenue requirement model. Petitioner's Exhibit Number 49, the updated revenue requirement model and Excel version. Petitioner's Exhibit Number 40, Petitioner's response to the Commission's docket entry dated August 21st, 2024, and filed. I'm going to get there. Petitioner's Exhibit 50. Petitioner's response to Commission's docket entry request dated August 21st, 2024, filed August 23rd, 2024. And Petitioner's Exhibit Number 50C, that's 50C, confidential work papers of Maria T. Diaz, filed in Excel, provided in response to the Commission's docket entry dated August 21st, 2024, filed on August 23rd, 2024.
Okay, I'll now ask each party whether they have any objections to those offered exhibits, including the change to Petitioner's Exhibit 45. Block LLC, any objections? Block LLC indicates no objections. Citizens Action Coalition?
No, Your Honor.
City of Westfield?
No, Your Honor.
Duke Industrial Group?
No objection, Your Honor.
Nucor Steel?
No objection, Your Honor.
River Ridge Development Authority, River Ridge Property Owners Association, and Rolls-Royce Corporation?
No objection, Your Honor.
Sierra Club? Sierra Club indicates no objection. Steel Dynamics, Inc.?
No objection.
Steel Dynamics indicates no objection. Wabash Valley Power Association?
No objection, Your Honor.
Walmart?
No objection, Your Honor.
OUCC?
No objection.
Petitioners Exhibits 1 through 26 inclusive, and Petitioners Exhibits 28 through 50 inclusive, as well as Petitioners Exhibits 2C, 6C, 16C, 19C, 20C, 21C, 22C, 23C, 30C, 32C, 33C, 42C, 43C, and 50C are admitted into the record without objection. Mr. Wells, it's my understanding you have some live testimony to present as well today, but as I indicated earlier, we'll now take a pause in petitioner's admission of evidence, and we'll now move on to the next party to admit any pre-filed exhibits and testimony they want to admit.
Thank you, Your Honor.
Block LLC.
Nothing from Block LLC, Your Honor.
Thank you, Mr. Rampala. Citizens Action Coalition.
Thank you, Your Honor. I do have one matter that I should have flagged earlier. I have noted in my list here what I've marked as CAC Exhibit 7, which is the transcript of the August 8th New Albany field hearing. Since that occurred after the time of our testimony, I've made that into a separate exhibit. I emailed and notified the parties. We had a robust discussion on whether or not the field hearing transcript should be made into a separate exhibit, but my understanding is if CAC had not requested it and made it into a transcript, it wouldn't have come out of the court reporter's raw form. So I've made it into CAC Exhibit 7, and I just wanted to clarify that and see if anybody had any objection to that, if I need to remark that or whatnot.
Okay. Why don't you go ahead and move to admit your other exhibits as well, and we'll cover this party by party. Thank you.
Okay, thank you. CAC would move what has been marked as CAC Exhibit 1, the public direct testimony and attachments of Benjamin Inskeep with corrections on pages 31, 44, 45, and 62 incorporated. That also includes one Excel attachment on a disk. CAC Exhibit 1C, the confidential pages of direct testimony and attachments of Mr. Inskeep, which includes 3 Excel documents on a disk. CAC Exhibit 2, the public direct testimony and attachments of Richard McCann, which includes 1 Excel attachment on a disk. CAC Exhibit 2C, the confidential pages of direct testimony and attachments of Richard McCann, which includes 2 Excel attachments on a disk. CAC Exhibit 3, the public direct testimony and attachments of Dr. Indra Frank. CAC Exhibit 4, the public direct testimony attachments of Devi Glick, which includes 4 Excel attachments on a disk. CAC Exhibit 4C, the confidential pages of direct testimony and attachments of Devi Glick, which includes 6 Excel attachments on a disk. CAC Exhibit 5, which is the public cross-answering testimony and attachments of Benjamin Inskeep. CAC Exhibit 5C, the confidential pages of cross-answering testimony and attachments of Mr. Inskeep, which includes 2 Excel attachments on a disk. CAC Exhibit 5, highly confidential, which are the highly confidential pages of cross-answering testimony of Benjamin Inskeep, meaning that only certain parties who have an additional non-disclosure agreement can see this information. CAC Exhibit 6.
Ms. Washburn, how is CAC Exhibit 5 highly confidential marked numbering-wise?
It is marked CAC Exhibit 5-HC.
Thank you. Please continue.
CAC Exhibit 6, which is a disk of CAC's public work papers. CAC Exhibit 6C, which is a disk of CAC's confidential work papers. CAC Exhibit 6-HC, which is a disk of CAC's highly confidential work papers. And finally, as noted before, the CAC Exhibit 7, which is a transcript of the August 8th New Albany field hearing.
Okay, any objections to these exhibits from petitioner?
No objection, Your Honor.
Block LLC? Block has no objections. City of Westfield?
No objection.
Duke Industrial Group?
No objection, Your Honor.
Nucor Steel?
No objections, Your Honor, but for a point of clarification, the highly confidential information has been served only on certain parties in this proceeding. So I believe that's CAC, OUCC, Duke, and Nucor. So we just want to be mindful in the event that there's references to that information. Not all parties have access to it.
Thank you. Just be sure to note that at the time of relevant testimony. We'll address it at that point in time. Thank you for that notation.
Thank you.
River Ridge Development Authority, River Ridge Property Owners Association, and Rolls-Royce Corporation.
No objection, Your Honor.
Sierra Club. Sierra Club indicates no objection. Steel Dynamics.
No objection.
Wabash Valley Power Association.
No objection, Your Honor.
Walmart.
No objection, Your Honor.
OUCC.
No objection, Your Honor.
Citizens Action Coalition, Exhibits 1, 2, 3, 4, 5, 6, and 7, as well as 1C, 2C, 4C, 5C, 5HC, 6C, 6HC are admitted into the record without objection.
Your Honor, this is Kurt Bain with Kroger.
Thank you.
I think I've been left off your list.
I'm so sorry, Mr.
Yeah,
Bain.
no problem. And I have no objection to anything that was entered previously.
Thank you for that notation, and thank you for letting me know that I skipped over you. I apologize for that oversight. All right, Ms. Washburn, anything further at this time?
No, thank you, Your Honor.
Okay, City of Westfield?
Thank you, Your Honor. At this time, the City of Westfield offers into evidence what's been marked as Intervenor City of Westfield's Exhibit 1, which is the pre-filed testimony of Scott Willis.
Any objection from petitioner?
No objection, Your Honor.
Block LLC? No, Your Honor. Block has no objection. Citizens Action Coalition?
No objection.
Duke Industrial Group?
No objection, Your Honor.
The Kroger Company?
No objection, Your Honor.
Nucor Steel?
No objection, Your Honor.
River Ridge Development Authority, River Ridge Property Owners Association, and Rolls-Royce?
No objection, Your Honor.
Sierra Club? Sierra Club has no objection. Steel Dynamics, Inc.?
No objection.
Wabash Valley Power Association?
No objection, Your Honor.
Walmart?
No objection.
OUCC?
No objection, Your Honor.
Westfield Exhibit 1 is admitted into the record without objection. Ms. Schultz, anything further at this time?
No, Your Honor, thank you.
Duke Industrial Group, any exhibits?
Yes, thank you, Your Honor. The industrial group submits into evidence the direct testimony and attachments of Michael P. Gorman as IG Exhibit 1, including revisions. As IG Exhibit 1C, the confidential portions of Mr. Gorman's testimony and attachments. IG Exhibit 2 is the pre-filed testimony as revised and attachments of Brian C. Andrews. Exhibit 2C is the confidential portions of Mr. Andrews' testimony and attachments. IG Exhibit 3 is the pre-filed testimony of Brian C. Collins with attachments. IG Exhibit 3C is the confidential portions of Mr. Collins' testimony. And finally, IG Exhibit 4 is the cross-answering testimony and attachments of Brian C. Collins.
Mr. Richardson, you indicated that Industrial Group Exhibit 1 is inclusive of revisions. Are those revisions reflected in the pre-filed version?
We have filed the revisions, Your Honor.
I'm sorry, I couldn't hear, Mr.
Yes,
Small.
they have been filed.
Okay, thank you. Any objections to Industrial Group's exhibits? Petitioner?
No objection, Your Honor.
Block LLC?
Diverse and numerous, Your Honor. I'm kidding, Your Honor. No objections from Block LLC.
Thank you, Mr. Impala. Citizens Action Coalition?
No objection.
City of Westfield?
No objection.
Duke Industrial Group?
We do not object, Your Honor.
I'm right there with Mr. Impala. The Kroger Company?
No objection, Your Honor.
Nucor Steel?
No objection.
River Ridge Development Authority, River Ridge Property Owners Association, Rolls-Royce?
No objection, Your Honor.
Sierra Club? Sierra Club has no objection. Steel Dynamics?
No objection.
Wabash Valley Power?
No objection, Your Honor.
Walmart?
No objection.
OUCC?
No objection, Your Honor.
Industrial Group's Exhibits 1 through 4, including 1C, 2C, 3C, are admitted into the record without objection. Mr. Richardson, anything further at this time?
Thank you. Nothing further.
The Kroger Company?
Thank you, Your Honor. Kroger submits into evidence Kroger Exhibit 1, which is the direct testimony of Justin Bieber.
Any objections from petitioner?
No objection, Your Honor.
Block? Block has no objection. Citizens Action Coalition?
No objection.
City of Westfield?
No objection.
Duke Industrial Group?
No objection, Your Honor.
Nucor Steel?
No objection.
River Ridge Development Authority, River Ridge Property Owners Association, Rolls-Royce?
No objection, Your Honor.
Sierra Club? Sierra Club has no objection. Steel Dynamics?
No objection.
Wabash Valley Power Association?
No objection, Your Honor.
Walmart?
No objection.
OECC?
No objection, Your Honor.
Kroger's Exhibit 1 is admitted into the record without objection. Mr. Boehm, anything further?
Nothing further, thank you.
Okay. Nucor Steel?
Thank you, Your Honor. At this time, Nucor offers into evidence its pre-filed exhibits, which consists of Nucor Exhibit 1, the public direct testimony and attachments of Jay Zarnicki, Nucor Exhibit 1C, the confidential pages of the direct testimony of Jay Zarnicki, and Nucor Exhibit 2, the cross-answering testimony and attachments of Jay Zarnicki.
Petitioner, any objection?
No objection, Your Honor.
Block? Citizens Action Coalition?
No, Your Honor.
City of Westfield?
No, Your Honor.
Duke Industrial Group?
No objection.
Kroger Company?
No objection.
River Ridge Development Authority, River Ridge Property Owners Association, Rolls-Royce?
No objection.
Sierra Club? Steel Dynamics?
No objection.
Sierra Club said no objection. Wabash Valley Power Association?
No objection, Your Honor.
Walmart?
No objection.
OECC?
No objection, Your Honor.
Nucor Steel's Exhibits 1, 1C, and 2 are admitted into the record without objection. Ms. Becker, anything further at this time?
No, Your Honor. Thank you.
River Ridge Development Authority?
Thank you, Your Honor. At this time, River Ridge Development Authority has no testimony in the case. I can move on to River Ridge POA if you'd like.
Please, thank you.
Thank you, Your Honor. At this time, River Ridge POA would like to move for admission into evidence Intervenor RRPOA's Exhibit 1C, and Intervenor RRPOA's Exhibit 2C. As we discussed off the record, we will provide the public versions of that testimony and offer them into evidence later in the hearings.
Thank you, Ms. Wheeler. Petitioner, any objection?
No objection, Your Honor.
Block? Block has no objection. Citizens Action Coalition,
No objection, Your Honor.
City of Westfield,
No objection.
Duke Industrial Group,
No objection, Your Honor.
Nucor Steel,
No objection, Your Honor.
River Ridge Development Authority,
No objection, Your Honor.
Rolls-Royce,
No objection, Your Honor.
Sierra Club. Sierra Club has no objection. Steel Dynamics,
No objection.
Wabash Valley Power Association,
No objection, Your Honor.
Walmart,
No objection.
OUCC,
No objection, Your Honor.
River Ridge Property Owners Association, Exhibits 1C and 2C are admitted into the record without objection. Ms. Wheeler, do you want to continue on with Rolls-Royce?
Yeah, I'm sorry.
I'm sorry, Your Honor, and again, I was skipped on that one.
Over for 2, thank you.
And no objection.
Thank you, Mr. Bain. Ms. Wheeler.
Thank you, Your Honor. On behalf of Rolls-Royce Corporation, we move to admit Intervenor Rolls-Royce Exhibit 1, the pre-filed direct testimony of Warren White.
Petitioner, any objection?
No objection, Your Honor.
Block? Citizens Action Coalition,
No objection, Your Honor.
City of Westfield,
No objection.
Duke Industrial Group,
No objection, Your Honor.
the Kroger Company, if you'd like a turn,
Yes, please. No objection. Thank you.
Nucor Steel,
No objection, Your Honor.
River Ridge Development Authority and River Ridge Property Owners Association,
No objection, Your Honor.
Sierra Club. Sierra Club has no objection. Steel Dynamics, Inc.,
No objection.
Wabash Valley Power Association,
No objection, Your Honor.
Walmart,
No objection, Your Honor.
OECC,
No objection, Your Honor.
Rolls-Royce Exhibit 1 is admitted into the record without objection. All right. Mr. Smith with the Sierra Club, is my understanding. Do you want to go ahead and make your record here?
Thanks for your patience. Joshua Smith on behalf of Sierra Club. As we've discussed prior to the hearing and with the other parties.
You have to get to the mic so the streaming audience can hear you.
Thank you. Sierra Club intends to offer its direct testimony into the record next week with Your Honor's permission.
Thank you, Mr. Smith. Steel Dynamics?
Thank you, Your Honor. Steel Dynamics has no testimony to offer into the record.
Wabash Valley Power Association?
Nothing from Wabash Valley Power Association. Thank you.
Walmart?
Yes, thank you, Your Honor. Walmart submitted evidence in this case that we marked as the direct testimony of Lisa V. Perry. I also recognize, and at the risk of unnecessarily complicating things, that we have identified her attachments as exhibits. I don't want to complicate things, but I'll defer to Your Honor whether we want to have that marked as attachments to keep in consistency with the commission's conventions.
I think we'll just admit them collectively as Walmart Exhibit 1 unless there's any particular objection or
No,
issues
not
you
at
see
all,
with that
Your Honor.
approach.
Thank you. Walmart would move for the admission of Walmart Exhibit 1.
Okay, thank you for flagging that potential issue. Petitioner, any objection?
No objection, Your Honor.
Block? No objection, Your Honor. Citizens Action Coalition?
No objection, Your Honor.
City of Westfield?
No objection.
Duke Industrial Group?
No objection, Your Honor.
The Kroger Company?
No objection, Your Honor.
Nucor Steel?
No objection, Your Honor.
River Ridge Development Authority, River Ridge Property Owners Association, Rolls-Royce?
No objection, Your Honor.
Sierra Club? Sierra Club has no objection. Steel Dynamics?
No objection.
Wabash Valley Power Association?
No objection, Your Honor.
OECC?
No objection, Your Honor.
Walmart Exhibit 1 is admitted into the record without objection. Mr. Nom, anything further at this time?
No, and I thank you for the accommodation, and I've drawn that to my own attention for the next time I appear before at this commission. Thank you.
Very well, thank you. OUCC?
Thank you, Your Honor. The OUCC would move for admission, the public would move for admission of Public's Exhibit Number 1, the public redacted testimony of OUCC witness Michael D. Eckert with all attachments. Public's Exhibit Number 1C, the confidential unredacted testimony of OUCC witness Michael D. Eckert with all attachments. Public's Exhibit Number 2, the public redacted testimony of OUCC witness Mark E. Garrett with all attachments. Public's Exhibit Number 2C, the confidential unredacted testimony of OUCC witness Mark E. Garrett with attachments. Public's Exhibit Number 3, the testimony of OUCC witness Caleb G. Lantrip with attachments. Public's Exhibit Number 4, the testimony of OUCC witness Brian R. Latham with attachments. Public's Exhibit Number 5, the public redacted testimony of OUCC witness Cynthia M. Armstrong with attachments. Public's Exhibit Number 5C, the confidential unredacted testimony of OUCC witness Cynthia M. Armstrong with attachments. Public's Exhibit Number 6, the public redacted testimony of OUCC witness Brian A. Wright with attachments. Public's Exhibit Number 6C, the confidential unredacted testimony of OUCC witness Brian A. Wright with attachments. Public's Exhibit Number 7, the testimony of OUCC witness Rupali Sanka with attachments. Public's Exhibits Number 8 and 9, the two exhibits containing the testimony of OUCC witness David J. Garrett with attachments, one considering the return on equity and one considering depreciation. Public's Exhibit Number 10, the testimony of OUCC witness John W. Hanks with attachments. Public's Exhibit Number 11, the public redacted testimony of OUCC witness David E. Dismukes, Ph.D. with attachments. Public's Exhibit Number 11C, the confidential unredacted testimony of OUCC witness Dr. David E. Dismukes with attachments. Public's Exhibit Number 11CA, the cross-answering testimony of OUCC witness Dr. David E. Dismukes with all attachments. Public's Exhibit Number 12, the consumer comments received by the Indiana Office of Utility Consumer Counselor and pre-filed on July 11, 2024. Public's Exhibit Number 13, the consumer comments received thereafter by the Indiana Office of Utility Consumer Counselor and pre-filed this past week. And that rounds out our list.
Petitioner, any objections?
No objection, Your Honor.
Locke? No objection. Citizens Action Coalition?
No objection.
City of Westfield?
No objection.
Duke Industrial Group?
No objection.
Kroger Company?
No objection.
Nucor Steel?
No objection.
River Ridge Development Authority, River Ridge Property Owners Association, Rolls-Royce?
No objection.
Sierra Club? Steel Dynamics?
No objection.
Wabash Valley Power Association?
No objection, Your Honor.
Walmart?
No objection.
And this, for the record, Sierra Club indicated no objection. I don't know if that got picked up. WCC exhibits 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 1C, 2C, 5C, 6C, 11C, 11CA are admitted into the record. Did I say exhibit 14, Mr. Harper?
Your Honor, I was
I
just
did
going
not mean to
Exhibit
admit,
14.
state exhibit 14. We'll into that exhibit 13. Mr. Harper, anything further at this time?
The only thing, Your Honor, is for the record, the Indiana Office of Utility Consumer Counselor anticipates pre-filing Exhibit 14, which would be additional consumer comments. We would pre-file that on September 3rd, and then we would tender that for the record on Wednesday, September 4th. We potentially would have a Exhibit 14A with additional comments thereafter.
Thank you, Mr. Harper. All right, at this time I'll swear in the witnesses. Will all who know themselves to be witnesses in this cause please stand if you're able and raise your right hand to be sworn? Do you swear or affirm the evidence you will give in this cause will be the truth, the whole truth, and nothing but the truth? Okay, thank you. You may be seated. Counsel, petitioner, whenever you're ready.
Thank you, Your Honor. At this time, petitioner would call to the stand Mr. Stan Pinniger.
And Mr. Pinniger, if you would please approach the witness stand and we'll go off the record. Yes, ma'am. Linda, you ready? Okay, let's go back on the record. Ms. Steffes, when you're ready.
Good morning, Mr. Pinniger.
Morning.
Could you please state your name and your business address for the record?
Sure. My name is Stan Penniger. I work at Duke Energy, Indiana, 1000 East Main Street, Plainfield, Indiana.
And by whom are you employed and in what capacity?
Duke Energy, Indiana, as president of the utility.
Could you please confirm that the documents in front of you are Petitioner's Exhibit Number 1, your direct testimony inclusive attachments 1A through 1C, as well as Petitioner's Exhibit Number 28, your rebuttal testimony inclusive of attachment 28A?
Yes, ma'am.
Thank you for confirming. Your Honor, Mr. Pinniger is available for cross-examination.
Block any cross? Citizens Action Coalition.
Thank you, Your Honor. I do have 2 exhibits, cross exhibits. Does it make sense to go ahead and mark those now?
Yes.
Okay, thank you.
We'll go off the record while that's being accomplished.
Thank you.
Excuse me, Your Honor. Excuse me, Your Honor. Are we on or off the record? We're off?
We're off the record.
Would it be possible to request that the Indiana Office of Utility Consumer Counselor begin cross-examination, the initial, prior to the other parties? And does anybody have any objection to that?
Just a moment, Mr. Harper. All right, Ms. Washburn, why don't you go continue handing out your cross-examination exhibits? Mr. Harper, excuse me, Ms. Washburn, go ahead and continue handing those out. Mr. Harper's request that they go first in cross-examination. Anybody have any objections? Petitioner?
No objection.
Okay. All right, Mr. Harper, as soon as Ms. Washburn is finished, we'll get back to you. Do you have any cross-examination exhibits to mark?
I do.
Go ahead and mark those. All right, Mr. Harper, you ready? All right, let's go back on the record. When we went off the record, it was the Citizens Action Coalition was preparing to cross-examine Mr. Pinniger. While we were off the record, Mr. Harper of the OUCC indicated that the OUCC would prefer to conduct its cross-examination first. Parties, any objection, I'm just going to ask you in mass. Does anyone object to Mr. Harper going first? Seeing no objection, Mr. Harper, please proceed when you're ready. I'd also note it's currently approximately 10:30. We were scheduled for take a break at 11. Since we're just now getting into the substance of the evidence, I won't be planning on breaking not until 11:30. Mr. Harper, when you're ready, please proceed.
Thank you, Your Honor. Good morning, Mr. Pinniger.
Good morning.
My name is Tom Harper, and I'm with the Indiana Office of Utility Consumer Counselor, appearing for the public. And I have some questions about your testimony and your role in the case today. I understand that you have testified before the commission before, and that was during Duke's last rate case, which is cause 45253.
That's correct. I also testified in our TDIS 2 proceeding.
Thank you. What materials do you have on the witness stand with you today?
Just what's been put on the table, my direct and rebuttal testimony, the notifications, various publications of our service territory, the exhibits that you just placed before me, and I have some CAC exhibits as well.
Okay, thank you. As president of the company, one of your roles is as the policy witness, is that correct?
Yes, sir.
Thank you. And you also sponsored the petition in this case?
I did.
Do you review and approve the testimony that is filed, of the witnesses that are filed on behalf of the company?
I certainly reviewed and approved my own. I've reviewed the other witnesses' testimony. I didn't approve those pieces of testimony.
Did you disapprove of any of the testimony?
I didn't. I neither approved nor disapproved.
Okay. Thank you. And according to your testimony, and if you need to refer to your testimony, please feel free to ask, and I can direct you to
Absolutely.
Where I am locating it.
Okay.
So according to your testimony, your direct testimony at page 2, your additional roles in this case and with respect to your testimony are to provide an overview of the requested relief, introduce and summarize the witnesses, provide an overview of the drivers of the requests, provide an overview of your operations, your transition to cleaner energy future, an overview of the company's actions to alleviate affordability issues and focus on financially vulnerable customers, an overview of the company's pursuit of federal funds, an overview of the company's economic development efforts, and an overview of the rate class notices and field hearings. Is that correct?
That sounds correct, yes.
Okay. And as part of your testimony, you analyzed affordability along with the other 5 pillars set forth in Indiana Code Section 8-1-2-0.6.
Yes, sir.
And did you specifically approve of the request written in the petition you sponsored for an overall annual increase in revenues from base rates and charges of approximately $491.5 million?
Yes, sir.
And that being approximately a 16.20% increase?
That sounds right, yes, sir.
Thank you. And in the prior rate case, you had also specifically approved the request for an approximate 18.6% increase in the company's case, which was filed July 2, 2019.
I don't remember addressing that in my direct testimony.
Okay. Can I have you refer to what's been marked for identification purposes as Cross Exhibit CX1?
I have it in front of me.
Okay. And in the pages, can you please take a moment and review pages 17 through 21?
Okay.
Okay, and then turning back to page 17 at lines 21 and 22, you characterized the last rate case request as an 18.6% increase. Is that correct?
That's what the transcript reflects, yes.
Thank you. And prior to the July 2019 base rate case, the company hadn't filed a base rate case for approximately 16 years. Is that correct?
That's what I remember and the transcript reflects.
Okay, thank you. The company was able to recover additional revenues between that gap for trackers.
That's correct.
Okay. In this rate case, under its TDSIC plans, the company has added capital of $1.6 billion since its last rate case. That's located at your page 4, direct testimony, lines 4 through 7, if you would like to reference that.
Could you repeat the page and line numbers, please?
Yes, sir. Page 4, lines 4 through 7.
Could you repeat the question, please?
Yes. So as part of this rate case, and under your TDSIC plans, specifically those TDSIC plans, the company has added capital of $1.6 billion since its last rate case.
That's correct.
Okay, thank you. So this rate case is also driven in part by trackers?
Well, it's driven by the statutory provisions provided under the TDISC provisions. The TDISC statute, as you're aware, allows 80% recovery of those investments, and the remaining 20 is deferred until the next rate case.
Okay, thank you. And those are, the TDISC process pre-approves those infrastructure investments?
Well, the commission, yes, there was a proceeding, as I mentioned, that I testified in. Our TDISC, this would include some of TDISC 1 as well as TDISC 2 investments that were made, and we are seeking recovery of those 20% deferrals.
Okay. So the current rates include the trackers and pre-approvals prior to the last rate case, and then incrementally, this case is also driven in part by pre-approved trackers. Is that correct?
Well, as I said, the statute requires a rate case to recover that 20% deferral. I'll mention also this statute also requires a rate case to be filed within the, in our case, 6-year TDISC plan.
Okay. According to your testimony, the proposed increase, and this is at your direct testimony at page 8, approximately line 14. According to your testimony, the proposed increase for a residential customer using 1,000 kilowatts per month would be approximately 19%, or $27.63 in increase.
That's correct.
Okay. And Ms. Graff cites the amount of $170.67 for the case-in-chief proposed rates, base, and trackers for residential at 1,000 kilowatts per month. Would you dispute that, or would you agree with that?
Could you please repeat that question?
Yes. Ms. Graff, in her testimony, calculates the amount of the increase to be $170.67 for the proposed rates, base, and trackers.
I believe that's correct. That includes TDISC, environmental compliance riders, and the sunset of a credit that is currently being provided customers.
Okay, thank you. And the rate request in this case, the petition also includes some requests for some additional trackers.
Well, Mr. Veterami supports the establishment of a fuel variable tracker. That's the only one that comes to mind.
Okay, thank you. In this rate, and this would be your direct at page 7, line 22, through the top of page 8. So in this rate case, you are also seeking new depreciation accrual rates.
That's correct.
Okay. And located at your direct at page 11, lines 1 through 7, the drivers for the rate increase include inflation, capital cost investment of the $2.8 billion, and the growth of rate base by $2.3 billion.
What lines did you begin on, sir?
Lines 1 through 7.
And could you repeat the question so I can follow along with my testimony, please?
Yes, I'm just asking regarding the drivers for this race case. Including inflation, capital cost investment, investment of the $2.8 billion, and rate base grown by $2.3 billion.
That's correct.
Thank you. And at your direct at page 13, lines 15 through 16, an additional significant driver of this rate case is coal combustion residuals and the treatment and costs for coal ash. Is that correct?
That's correct.
And you state on page 14, lines 7 through 8, that one of the significant issues in this case is to assure the recovery of future closure costs.
That's correct.
Okay, but the company is not revisiting recovery of costs disallowed by the Supreme Court due to the retroactive rate making, and that's located at page 14, lines 3 through 5.
That's correct.
Let's go off the record for a moment. Mr. Harper, please proceed. In the future, please ask for permission to approach the witness. But go ahead and take care of what you're going to take care of now. Mr. Harper, do you have copies for the bench? Let's go back on the record. Mr. Harper, please continue.
Thank you, Your Honor. Mr. Pinniger, I've handed a page from Petitioner's Exhibit Number 3, which has been previously admitted. This is Krista Graff's testimony at page 8, and I wanted to direct your attention to Table 3, the rate increase components.
You see it?
Thank you. This reflects that the rate of return on base increases account for 2.7% of the rate increase. Is that correct?
Well, I didn't prepare this table. I'm not very familiar with it, but that appears to be the reflection on the table.
Okay. You wouldn't have any specific disagreement with those percentages, would you?
I had no direct involvement in the development of the table.
Okay.
And Ms. Graff will be available for cross-examination.
Okay, thank you. Directing further, the table indicates the rate of return at 10.5%. Well, it doesn't indicate the rate of return. The rate of the return on equity Duke requests that you included in your testimony was 10.5%. Is that correct?
That's correct.
And in Table 3, it indicates that the rate of return in financing costs in the other cost structure changes category accounts for 9.5% of the rate increase. Is that correct?
Well, again, I believe Ms. Graff would be since she prepared this table, a better witness to comment on the
Okay,
various elements of the table itself.
okay. Assuming that Ms. Graff is accurate, then the rate of return in financing costs would account for 9.5% of the rate increase that's requested.
That's what the table indicates.
Okay. Assuming that Ms. Graff is correct, the depreciation rates, excluding depreciation for rate base increases, accounts for 4% of the rate increase.
All I see is depreciation rates. You added another segment to that line I didn't hear. But
Okay. Under the rate base category, it indicates depreciation for rate base increase is 1.8%, correct?
Objection, Your Honor. Mr. Pinniger has indicated that this was best addressed by Ms. Graft, who will be available for cross-examination, and this is her testimony, and this is her table.
Mr. Harper?
Yes, Your Honor, but Mr. Pinniger is responsible for approving the entire request of which these components are part. And these are overview questions, so he is an appropriate witness as a policy witness and overview witness with respect to the rate request and the drivers and components.
Steffes?
Your Honor, Mr. Pinniger said explicitly that he did not approve nor disapprove the testimony in this case. And he is asking highly specific questions about the testimony of another witness who will be available for cross-examination.
I'm going to overrule the objection. To the extent that Mr. Pinniger is able to answer the question, he may certainly do so. He certainly knows that if he is unable to answer a question, then that is an option as well. But the objection is overruled. Mr. Harper?
Could we have the question read back?
that's reflected on the table.
Okay. And if you switch over to page 9, it shows that the total request is 16.2%, which is consistent with your prior testimony.
I'm familiar with that
Okay.
particular figure.
So if you look at the depreciation rates under other cost structures, it would be reasonable to assume that those are the depreciation rates that are not also depreciation for rate base increase that's included above.
I really don't feel that I can answer that question. I would lead you to Ms. Graff.
Okay. Let's assume that that's correct. When you add the rate of return on base increases, the amount of 2.7%, and the rate of return, the rate of return in financing costs, which accounts for 9.5%, and the depreciation rates, which accounts for 4%.
Objection, Your Honor. Mr. Pinniger has been asked this question and it has been answered. He has indicated that he does not know and that is deferred to Ms. Graff, excuse me.
Mr. Harper?
Could I finish my question, Your Honor?
State your question.
Can I state my question, restate my question, and finish?
Objection sustained. Restate your question.
Thank you, Your Honor. Mr. Pinniger, assuming that those numbers are correct, when you add the return on rate base increase of 2.7%, the rate of return in financing costs at 9.5%, and the depreciation rate at 4%, by my math, that totals 16.2%. Would you agree or disagree that that amounts to 16.2%?
That's correct.
Okay.
It's cut to
So
16.2%.
assuming that's correct, then 16.2% of the company's 16.2% increase is rate of return and financing costs and depreciation accrual, excluding that 1.8% of depreciation for rate base increase. Would you agree or disagree?
Well, as I said, I really don't feel prepared to comment on this table. There are puts and takes associated with the table as well that we've not discussed, and I'm frankly not capable of discussing.
Okay, I'll move on. Thank you. Mr. Pinniger, would you agree generally that depreciation of capital investment is sometimes referred to as return of, as opposed to return on equity and weighted cost of capital, which is sometimes referred to as return on?
Could you repeat the question, please?
Yes. Would you agree generally that depreciation of capital investment is sometimes referred to as return of the investment?
Yes.
As opposed to return on equity and weighted cost of capital, which is sometimes referred to as the return on investment?
That sounds reasonable.
Okay. And in this case, the depreciation accrual study includes costs for coal combustion residuals and costs related to coal ash. Is that correct?
The depreciation study?
Yes.
Yes.
Okay. And those are future forecasted costs, correct?
Not the portion I was thinking of, no.
What portion were you?
Mr. Hill, in his testimony, addresses future coal ash expenditures.
And those future coal ash expenditures are included in the depreciation accrual rates. You're aware of that, correct?
I'm not specifically.
You're not aware of what's included in depreciation accrual rates?
Not specifically.
You indicated that you seek to assure recovery of those future costs, but you're not aware of those future costs being included in depreciation accrual rates?
I am aware of the first portion of your question, not so aware of the second portion of your question specifically.
At your direct testimony on page 14, lines 7 through 8, did you not indicate that one of the significant issues in this case is to assure recovery of future closure costs?
That is indicated, yes.
Okay. And those future closure costs, how are they being recovered as far as the proposed rate-making treatment in this case?
I have left that to Mr. Hill and Ms. Lilly.
So you're not aware that those are not recovered other than by depreciation accrual rates?
Objection, Your Honor. This is outside the scope of this witness's testimony and is better addressed by other witnesses in this cause.
Your Honor, may I respond?
Please.
This is included directly in his testimony regarding the assurance of recovery of future closure costs. He has addressed this and he's addressed the overview as well.
Steffes?
I think that Mr. Harper's question goes deeper than what is included in Mr. Pinniger's testimony, which is a high-level overview and a reference to other witnesses who discuss this.
The objection is overruled to the extent the witness may answer the question. He is directed to do so. Mr. Harper?
Can we have the question read back, please?
I wasn't aware of the mechanism, no.
Okay. What CCR costs are included in depreciation?
Well, we have included $95 million that was approved by the commission, found to be prudent, both from a prudency standpoint and a process standpoint, but overturned by the Court of Appeals.
But you're not aware of future costs included in cost of removal in the depreciation accrual study?
Objection, Your Honor. Mr. Pinniger has been asked to answer this question.
This is a separate question, Your Honor.
Objection's overruled.
Honestly, I had focused on the $95 million.
Okay. Are you familiar with the concept of cost of removal?
Not well, no.
I'm sorry, I didn't ask you if you knew it well. I just wanted to know if you
I
were
would say
familiar
no.
with it.
I am not an expert in cost of removal.
And I'm not asking if you're an expert. I'm just asking if you have an understanding of cost removal at all.
No.
Is cost removal reflected anywhere in testimony that you reviewed?
I've read the term, yes.
But you have no idea what that is?
Well, I knew that it was part of the, it was inserted as part of the depreciation.
How? What's your understanding, Mr. Pinniger?
I left that to Mr. Riley and Mr. Spanos.
Are you familiar with the term net salvage?
Well, I read Mr. Kopp's testimony. And again, I am not an expert in net salvage. I guess I'm familiar with the term. I read it in his testimony.
What does it mean to you?
Well, I do not have even a basic understanding of net salvage.
Generally, let's assume that cost of removal is a future forecasted cost to once a facility closes to make sure that all environmental issues are complied with once a facility closes and is retired. Are you familiar with facilities closing and retiring?
I am.
Okay. And let's assume that the cost removal is a forecasted cost for the company, which is then netted against the net salvage of whatever property remains at retirement.
Objection,
Okay.
Your Honor. This is outside the scope of Mr. Pinniger's testimony.
Mr. Harper.
Mr. Pinniger testifies regarding retirements, and he testifies regarding coal ash recovery. He testifies regarding seeking assurance of future costs. It's not outside the scope of his testimony.
Ms. Steffes.
Mr. Pinniger testified that he does not know what net salvage is, and his testimony addresses these issues at a very high level, and these issues are discussed further by other witnesses in this cause.
The objection was that this was outside the scope of his testimony. That objection is overruled. Mr. Harper.
Can you please read back the question, Ms. Court Reporter?
Was that phrased as a question? Sorry.
Yes, will you assume that as I walk through additional questions? Can we assume that?
That proposition made sense to me, yes.
Okay, thank you. Then let's further assume that those cost of removal are treated with respect to the retirement or closure of a coal generation plant.
That seems reasonable.
Okay. Then those would range from years to decades, wouldn't they?
What? The retirements? Or
Yes, the retirements and the following closure costs.
I'm not qualified to speak on the timeframes associated with removal. I would think it varies.
Would you think it would vary by years or decades, or do you
I
have?
have no idea.
Would the closures themselves range from years to decades based on what you understand from the IRP and which facilities are set to retire at which times?
It seems like a different question to me. The retirement dates certainly are part of the IRP.
And then would those range from years to decades?
I would not say decades, based on past IRPs.
Would you say they're going to retire? There are none that are going to retire within a decade?
Well, maybe just barely, yeah, within a decade.
Okay. And so, assuming that you have cost of recovery tied to the retirement of the plant, and that feeds into the depreciation accrual rates, which formulate the depreciation expense, those act as prepayments, do they not?
I don't know.
Could they be payments now to assure recovery of future costs?
I am not qualified to answer.
Not possible?
I don't know.
Okay. Do you know whether or not the company's depreciation accrual rates, accrual requests, strike that? Do you know whether or not Mr. Spanos' depreciation accrual study for cost removal also include requested contingency amounts for the future costs?
Objection, Your Honor. This is outside the scope of Mr. Pinniger's testimony.
I'm asking if he knows, Your Honor.
How is this within the scope? Do you respond directly to her statement that this is outside the scope of his direct?
It goes to the overview of the rate request and the depreciation that's included as a driver of the rate increase.
Ms. Steffes?
I would disagree. I believe that the question is specific to Mr. Spanos' testimony.
Objection is overruled in the sense that it gets to his overview of these issues, one of which would include Mr. Spanos' testimony. Mr. Harper, please proceed.
Can I ask that that be read back, please? Thank you.
I'm not familiar with that, no.
Okay, so you also would not be familiar with those depreciation accruals for the cost removal, including escalation, or would you be familiar with that?
I am not.
Okay, thank you. Does Mr. Spanos' depreciation accrual study include post-closure maintenance costs?
It does.
Okay. Do you know what contingency is
Yes.
Can you explain?
It is a projection of costs that may exceed a current estimate based on inflation, other issues that may come up.
So contingency is included to alleviate risks that are not known?
Sounds reasonable.
Okay. Do you know what the term escalation means?
I would assume rising costs.
I'm talking about escalation as a component of an estimate or future forecasted costs.
Not in the context of depreciation, no.
Okay. With the significant drivers in this case, including recovery of pre-approved investments and prepaid future costs, the major drivers of this rate case serve to alleviate risk. Would you agree or disagree?
I'm sorry, you mind repeating your question?
Yes.
Are you,
I wouldn't mind.
are you looking at my testimony when you're reading that?
No, this is an
okay.
overview. But you had testified earlier regarding the significant drivers, correct?
I did.
Okay. With the significant drivers in this case, including recovery of pre-approved investments and prepaid future costs, the major drivers of this rate case serve to alleviate risk. Would you agree or disagree?
I'm sorry, in what context? I don't know the context of your question.
You cannot
Generally?
answer my question.
Maybe could you rephrase it, please?
The significant drivers in this case include recovery of pre-approved investments and prepaid future costs. So the major drivers of this rate case increase serve to alleviate risk. Do you disagree or agree?
Objection, Your Honor. The witness asked that the question be rephrased. Mr. Harper did not rephrase the question.
Your Honor, I believe I did rephrase the question.
The question was rephrased. The witness can answer. He may answer.
May I have the question read back, please? Well, frankly, I'm not sure how to answer the risk portion. I think that under general rate-making principles, the assets that are enjoyed by the current customers should, to the extent practical, be paid for by current customers.
Turning your attention to your direct, page 14, lines 10 through 12. You state that affordability is driving this case in many ways. that correct?
Yes.
And then on your direct page 15, lines 8 through 10, you indicate that you've identified measures in this case to address affordability. Is that correct?
That's correct.
And you included 8 measures.
That's correct.
Turning to your rebuttal, page 9, lines 1 through 7.
I'm there.
You stated that your testimony reaffirms the company's commitment to affordability and emphasizing that affordability is a critical, integral part of the 5 pillars framework.
That's correct.
And in your rebuttal on page 22, lines 8 through 10, you indicate that the company's proposed rate increase is necessary in general. I'm sorry. I should have given you the time
22, what lines, please?
Lines 8 through 10.
I'm there. What was the question, please?
Yes, I'm sorry. You stated that the rate increase is necessary.
What I say is the case is necessary and prudent, the need to recover necessary and prudent investments. That's different than the case is necessary.
Are there parts of the request that are unnecessary?
None come to mind.
Okay. Have you previously stated that the company would forego post-closure maintenance costs as part of the depreciation accrual?
That was in my initially filed direct testimony.
So is that a yes?
Well, as you're aware, we filed revised direct testimony upon recognition of an error that was made internally on that topic.
And in your initial direct testimony, you stated that the company would forego post-closure maintenance costs as part of the depreciation accrual.
Yes, but we revised that direct testimony and assorted other pieces of direct testimony.
Your Honor, request to approach.
Granted. Let's go off the record.
Thank you.
Let's go back on the record, Mr. Harper.
Thank you, Your Honor. I'm referring to what you have in front of you that has been marked for identification purposes as Cross Exhibit 2, CX2.
Yes, I have it.
Can you identify that for me?
It's the revised testimony I just referred to, my own.
Okay. Is that a true and accurate copy?
I will presume so.
Thank you. Turning your attention to the red line beginning on page 4 of the exhibit. So second to last page of the exhibit.
Yes, sir.
Okay. Your prior statement was that in calculating depreciation accrual rates, we have excluded the future post-closure maintenance obligations associated with ash pond remediation. As is being explained by company witness Mr. Hill, the EPA is currently considering a revised and expanded coal combustion residual rule, and we have determined that it is better to incorporate the future post-closure maintenance obligation and depreciation rates to be set in the company's next general rate case or future federal mandate rider proceeding. Is that correct?
That's correct.
And in your initially filed testimony, that was one of the multiple steps that you took to address affordability.
It was, among many others, yes.
Okay. Is there a reason indicated on page 1 of Exhibit CX2 for the revision?
A reason for the correction?
Yes.
I don't see a reason for the correction, no.
Does it indicate upon review of petitioner's attachment 12A JJS, Duke Energy Indiana has discovered a discrepancy between certain testimony and attachment 12A JJS? Specifically, Duke Energy Indiana is removing references in testimony to post-closure maintenance costs not being included in depreciation rates. Attachment 12A JJS does in fact include those costs.
That's correct. I apologize. I missed that portion of the petition.
Okay, thank you. Now I want to direct your attention to cross-exhibit CX3 in front of you.
I have it.
Is that the revision to Mr. Spanos' testimony that the company filed?
It appears to be.
Okay. Does Mr. Spanos explain, strike that. Did Mr. Spanos initially testify that as explained by company witness Mr. Pinniger, the company later determined to exclude these future anticipated costs from the calculation of depreciation rates in an effort to mitigate the overall rate increase?
I missed the question. You confirming that's part of the revised testimony?
Is that what Mr. Spanos had said in his initial testimony that was filed?
It appears to be the case based on what is stricken in the document.
And that part of the document was then removed, correct?
That's correct.
Does that indicate to you that the depreciation study was intended to remove the post-maintenance costs, but it had not done so?
Well, Mr. Spanos obviously included it in his study at some direction.
Okay. And the company chose, instead of revising Mr. Spanos's, or asking Mr. Spanos to revise the depreciation study, the company chose instead to revise the testimony and remove that affordability measure. Is that correct?
Well, that's correct, but it had no impact on the initial rate, overall rate impact of the case.
Would you agree or disagree that the total post-closure maintenance costs in COPS decommissioning study were approximately $191 million?
I don't know.
Mr. Pinniger, the company didn't file a base rate case between 2004 and 2019. Is that correct?
We filed a case in 2019.
And it hadn't filed a base rate case between 2004 and 2019?
That's correct.
Okay. And other than the brief rate case moratorium under the 2012 Edwardsport settlement ending approximately March 2013, nothing you know of prevented the company from filing a base rate case between 2004 and 2019?
Well, I joined the company in 2012, so my knowledge of internal deliberations would begin at that point, and even the first 6 years of my stint with the company, I was not involved in those decisions.
Can I direct your attention to CX1?
Yes, sir.
And we've looked at that before, and that's the transcript of your cross-examination in the last rate case, correct?
Yes, with Mr. Hellman.
Okay. I want to direct your attention to page 7 of that exhibit, which is indicated to be page 48 of the transcript.
I'm there.
Okay. Question, aside from the brief rate case moratorium under the 2012 Edwardsport settlement, which lasted, I think, 3 or 4 months, am I correct that at any point since the rate order in 2004, the company could have filed a rate case at any point? And your answer was you believe that to be the case. Is that correct?
That's reflected in the transcript.
Okay. And the question was put to you that you're not aware of any legal impediment that prevented a rate case filing. And your answer was, I've not done that research, but that sounds correct. Is that accurate?
That sounds reasonable, yes.
Okay. And Mr. Riley testifies that at the end of 2014, the EPA had provided final rules addressing disposal of coal combustion residuals. Do you agree or disagree with that characterization?
Mr. Riley?
Yes.
I'm sorry, could you repeat the question?
Yes.
I got confused with Mr. Riley for a moment.
Okay.
Looking at an old transcript.
Mr. Riley's testimony includes that at the end of 2014, the EPA provided final rules addressing disposal of coal combustion residuals. Do you disagree with that statement?
I don't.
Okay. Are you aware that prior to 2019, the base rate petition, the company did not include future costs? It had not then, but would incur as in the future as a result of those CCR rules.
I'm sorry, are you still in Mr. Riley's testimony?
I'm asking you.
Please repeat the question.
Yes. Are you aware that prior to the company's 2019 base rate petition, the company did not include future costs that it hadn't yet, but would in the future incur as a result of those CCR rules that we spoke about just a moment ago?
I'm not trying to avoid your question. I'm not sure how to answer it. Maybe if it's rephrased.
You're aware that in 2019, the company had requested recovery of coal ash costs that it was incurring due to the CCR rule, correct?
That's correct.
So you're also aware that prior to 2019, before the company had incurred those costs, it could have sought pre-approval rate making for those costs. Is that correct?
I wasn't part of those legal deliberations. I don't know. I think that under the, I'm not sure when the federal mandate statute passed off the top of my head, but there are mechanisms beyond a rate case to recover for fairly mandated requirements.
Yes. And in March of 2016, the company filed cause 44765 when it was aware of costs, but did not include all of its costs for pre-approval rate making.
Objection, Your Honor. This line of questioning is outside the scope of this witness's testimony and this rate case in general.
Mr. Harper.
Your Honor, this goes to the company's position that it should receive a share of coal ash insurance proceeds because it was denied recovery. However, that recovery was at the choice of the company when it chose not to seek pre-approved rate-making treatment for the coal ash costs, but instead engaged in retroactive rate-making by attempting to recover them after the fact.
Ms. Steffes?
Your Honor, again, this is not in this witness's testimony and is outside the scope of the case. If Mr. Harper could point where in Mr. Pinniger's testimony he's referring to, that might be helpful.
Mr. Harper referenced Mr. Pinniger's, the objection is overruled for now, but reference the specific portions that you are getting to, please. Thank you.
Are you aware that the company's position is that it should receive a share of the coal ash insurance proceeds at issue in this case, claiming that it is entitled because it did not recover the retroactive rate-making coal ash costs that the Supreme Court had denied?
My understanding was that insurance proceeds are not part of this case.
Thank you. I have no, maybe we go off the record.
Yes, we'll go off the record. Mr. Harper, are you ready to proceed?
Yes, Your Honor, may we go
Let's go back on the record. Mr. Harper?
Thank you, Your Honor. I have a few more questions, but before I address those, I would move for admission of cross exhibits 1 through 4.
Petitioner, any objection?
Objection, Your Honor, to OUCC Cross Exhibit 4. There's been no foundation laid for its admission into the record, and it was, Mr. Pinniger was asked no questions about it.
What about 1 through 3?
No objection, Your Honor.
Block? Citizens Action Coalition?
No objection.
City of Westfield?
No objection.
Industrial Group? Kroger?
No objection.
Nucor?
No objection.
River Ridge Development Authority, River Ridge Property Owners Association, Rolls-Royce?
No objection.
Sierra Club? Sierra Club says no objection. Steel Dynamics?
No objection.
Wabash Valley?
No objection.
Walmart?
No objection.
OUCC cross-examine exhibits 1, 2, and 3 are admitted. Mr. Harper, what's your response as to CX4?
Your Honor, counsel is correct, and I withdraw the request to admit CX4.
Very well. Mr. Harper, please continue.
Thank you, Your Honor. Mr. Pinniger, earlier in your testimony, you referred to a fuel tracker from, referenced by Mr. Verderame.
That's correct.
Is that the fuel tracker for coal inventory?
It is.
Okay, thank you. Did you indicate in your testimony that you're not revisiting the Supreme Court's ruling on the cost recovery?
I did.
Okay, and you're not aware of the coal ash insurance proceeds issues in this case?
I'm not.
Okay. In addition, in your petition and your case, in this base rate case, the company is revisiting the Indiana Court of Appeals decision from 2023 that disallowed the $92 million of recovery under the federal mandate statute. Is that correct?
That's correct.
Okay, thank you, Your Honor. May we go off the record briefly, Your Honor?
Yes, let's go off the record. We'll go back on the record, Mr. Harper.
Thank you, Your Honor. The public has nothing further at this time.
All right, the time is 11:35. Let's take a 15-minute break until 11:50. Thank you, counsel. Now we're streaming. Okay. We're back on the record. Ms. Washburn, please proceed.
Thank you, Your Honor. Good morning, Mr. Pendergray.
Morning.
Nice to see you this morning.
You also.
You are the most senior official testifying on behalf of the company, correct?
That's correct.
Not age, just.
Thank you. What came to mind when you said it?
Since the last rate case, there has been some structural changes with Duke Energy Indiana. In particular, Duke sold a minority interest, roughly, I think it was 19.9% of Duke Energy Indiana to the Singapore Sovereign Wealth Fund. Is that correct?
Yes, GIC.
Okay, thank you. You're aware, that the government of Singapore does have control of the, I'm going to mispronounce this, but Genesee and Wyoming Inc. Railroad, and it's supplied to some of Duke's power plants, coal-fired power plants?
Well, I was aware that GIC had an interest in the railroad. I'm not privy to the percentage of ownership of the railroad, but yes.
Okay, thank you. Did this minority interest have any decision-making in some of Duke's decisions related to its coal plants?
No. We collaborate with GIC on a regular basis, but we've not included them in coal unit decisions at this point.
To the best of your knowledge, has Duke made any commitment to dedicate any of the proceeds from that $2.05 billion sales to its operations and investments in Indiana?
Well, it is indirectly. The proceeds went to Duke Energy Corporation to help with the enterprise's capital needs, and so we're benefiting from that as well.
But to the best of your knowledge, nothing specifically earmarked for Duke Energy Indiana?
No.
Okay, thank you. Would you agree Duke is very financially healthy?
Duke?
Yes.
Well, Duke, Indiana?
We can start with Duke Energy.
Okay. Well, it, like any business, it varies from year to year.
What about Duke Energy Indiana?
I would say the same.
Subject to check in 2023, Duke Energy Indiana produced a 263% year-over-year increase in profit. Are you aware of that?
I'm not sure of the percentage, but there certainly were some major anomalies in 2022 with respect to net income.
When is the last time Duke did not provide dividends to shareholders? Are you aware of that?
I think we take pride in providing dividends to shareholders.
So no time coming to mind when Duke did not?
I do not know.
Are there any funds that Duke spends itself that is not ratepayer money? It's not collected from ratepayer pocketbooks?
Well, certainly there are distinctions between shareholder-provided dollars and O&M.
So related to shareholder dollars, are you aware of any specific investments outside of foundation dollars and whatnot that are provided to Duke's operations?
Duke Corp, well, GIC is an example, but other than that, no.
You speak to affordability a lot in your testimony. With the aid of control find, I did count, you mentioned affordability, or some other variation 19 times in your direct and 36 times in your rebuttal. Were you aware of that?
I was not.
But are you aware that the requested increase is among the largest residential electric bill increases in a rate case nationally?
I was not aware of that. I think there could be many reasons for that. We've not been in 5 years. I know at least in Indiana, some of our peers have been in twice since we've been in. So the magnitude of the increase, I think, can be distinguished by number of rate cases.
Should we expect this type of cadence and magnitude of rate increases going forward? $42 a month increases for residential customers going forward? And
well, as you know, the actual rate case related increase is $27 at the full extent of the ask. We have not started planning our next rate case. I can't speculate on that. I've watched our peers, obviously.
as president of Duke Energy Indiana, are you concerned about the magnitude of the increase?
Well, as you know, we're meeting a lot of obligations. We have a statute, we have many statutes in place that require us to focus on policy-oriented needs of our customers, including the 5 pillars, including TDISC, including the obligation of federally mandated costs.
Which a lot of that creates a very low-risk environment, wouldn't you agree?
Well, there's 2 mechanisms.
The proliferation of trackers for our utility companies in Indiana legislatively.
Well, the mechanisms are helpful, but there is risk, certainly. I think we experienced that in 2022 with the write-off of $432 million in pre-tax revenue.
And you're referring to the disallowance by the courts about the coal ash costs?
I am, after the commission had found prudency and the procedural paths in which we pursued to be correct.
But you're still asking for that recovery here in this case, but through depreciation this time, correct?
A portion of it, yes.
$92 million, correct?
That's correct.
Going back to what you said earlier, this discrepancy between CAC's calculation of the monthly increase for residential customers being $42 versus Duke's being $27. Do you understand the differences between our differently calculated bill impacts? Could you walk us through that, please?
Well, it's in Ms. Graff's pro formas. We were transparent about that, I believe. And we had pre-existing TDISC matters as well as fairly mandated costs. And as I mentioned earlier, the sunsetting of the credit that played into that pro forma that Ms. Graff provided.
So for CAC's calculation of $42 monthly impact to customers, we were looking at a comparison between residential bills under Duke's current rates based on the published tariffs on its website at the time the rate case was filed, compared to Duke's proposed bill effective March 2026. Is that your general understanding?
I didn't do a calculation based on our tariffs. I relied on Ms. Graff's pro formas.
Are you aware that Duke's presentation of the $27 figure was what the bill increase would be over 2 years? So Duke projected future 2025 bills and compared its estimate of future bills without a base rate case.
In Ms. Graff's testimony?
Yes.
Well, I don't have that in front of me, but that sounds reasonable.
And there are additional Duke Energy Indiana bill increases anticipated after Step 2 rates are implemented in early 2026. Is that correct?
I would assume there will be ongoing, at least TDISC matters.
Will customers experience rate decreases from Duke anytime?
Well, that happened actually in coming out of the pandemic. As you're aware, our fuel and power purchase prices escalated considerably, 30%. And as we've entered into latter part of 23 and 24, certainly as coal deliveries have become more dependable and prevalent, and power purchase prices are low, there has been a substantial decrease in the customer's bill.
Looking back over the past 10 years, though, in aggregate, we've seen substantial residential bill increases, correct?
I wouldn't call it substantial in the last 10 years, no.
We've seen sizable Duke Energy Indiana residential bill increases. Would you agree with that?
Well, predominantly due to the fuel and power purchase price dilemma that we had coming out of the pandemic.
You review the affordability data that Duke reports? Are you generally familiar with disconnect notice and?
Not specific numbers, but generally.
Generally. So subject to check, looking at the CAC Exhibit 2. It's missing the 2023 figure, which is in work papers, and we can pull that up, but it's another $59,900 for December 2023. Subject to check if we add up the disconnect notices sent for non-payment for general residential customers and divide that over the total customers. Are you aware that 47.8% of your customers received disconnect notices in 2023? Residential customers?
Well, I'm not real sure what that number means. It could mean the same customer receiving multiple disconnects.
It could, yes. But does that concern you on affordability? Would you say, currently, those are current numbers under the current rates, 47.8% general residential customers received disconnect notices in 2023. Is that concerning to you?
Certainly. We don't want to disconnect a customer. And I am proud of the programs and products that Mr. Cawley emphasizes in his testimony with respect to vulnerable customers. It's not our goal to disconnect a customer. And we, I think, go to great lengths to avoid doing that.
But Duke has not, why didn't Duke offer a low-income bill assistance program in this case?
Well, I think it's been made pretty clear there's no statutory authority to do so, and the commission is reluctant to head down that path without statutory authority.
You have experience at the State House, correct?
A bit.
If Duke wanted to move forward with legislation enabling low-income programs, it likely could put forward a bill, correct?
Well, I've been disappointed before in bills I've wanted to put forward, so I think there have been bills actually put forward at the State House, even recently.
Did Duke support those bills?
I'm not sure they were heard.
What about securitization? Does Duke have any effort or any plans to move forward with securitizing, for example, the many expected generation retirements and the many expenditures we have coming down the road here with coal ash? Has Duke considered trying to work towards getting the legislation changed from a pilot phase and specifically to CenterPoint?
We've not had those discussions with legislators.
Why?
Well, there have been a lot of other priorities, as you know, that have been put forth at State House that have required a lot of attention. Securitization is not something that we have, without even knowing, frankly, as you're aware, in our IRP process and the uncertainty around the useful lives, how long those units will be running, it's not been part of our deliberations internally.
But Duke did prioritize the legislation related to retroactive rate making for the coal ash expenditures, correct?
What was the verb you used? I'm sorry.
Duke did prioritize pursuing legislation that would enable retroactive rate making for coal ash expenditures?
We worked on that bill, as did our peers.
Duke is requesting a 10.5 ROE, is that correct?
That's correct.
Assuming all of the requests are granted and recognizing there may be some adjustments now with rebuttal, but with the 10.5 ROE, that would amount to $491.5 million, correct?
That's correct.
If we drop down to a 9.0 ROE, that would drop it down roughly $110 million. Are you aware of that?
I wasn't aware of the figure, but it would put the utility in dire straits.
Duke would be in dire straits with
Duke
a
Energy
9%.
Indiana at a 9-point ROE, yes. I think Mr. Bauer, Mr. McKenzie certainly emphasized that point, both in their direct and certainly in rebuttal.
How do you balance a $42 a month increase with these shareholder desires?
Well, we're bound by the 5 pillars in Indiana. And the way I observe the 5 pillars, certainly affordability, is I think I was criticized for calling it a relative analysis. And we could quibble with words, but I think and I clarified this in my rebuttal, we are charged with providing reliable, resilient, stable service and addressing our environmental requirements. And I think we're doing that very well, and I think we'll continue to do that well, and I think this case sets us up to continue to do that well. The affordability component has two words I think that are important to emphasize: affordability and competitiveness within the statute. I think by all accounts we're very competitive. We entered the case with the second lowest rates among our Indiana peers. The commission just published an average bill survey in early July, and we have moved to the lowest average bill among our 5 IOU peers.
But that is your current.
That's correct.
Rate, not incorporating the $42 a month increase.
That's correct. Okay. I agree.
Duke's executive compensation, $20.6 million in total 2023 compensation to Lynn Good, $48.6 million in Duke stock. Should ratepayers have to pay so much for leadership at Duke?
Well, 2 things about Ms. Good. Well, many things about Ms. Good. Her total compensation, like all of the employees at Duke Energy, is market-based, and Indiana receives a proportional share of those costs. Duke Energy Indiana, about 10%. She's an outstanding leader. She's been in that role. I've been fortunate to serve under her leadership essentially my whole time at Duke for 12 years, which is an anomaly in the utility industry. Her experience and expertise is invaluable. She has a huge responsibility with over 10 million customers, 27,000 employees, and she does it very well. She motivates her employees, she motivates me. every day. It's one reason I'm at Duke.
She's worth $69 million a year?
Well, that's what the market-based professionals have determined.
As Duke Energy Indiana president for Indiana, don't you think there's some places to trim fat in that, in the executive compensation?
Well, obviously, our board and others have seen value in her service. As I mentioned, she's long-standing CEO of the company, well-regarded in and outside the utility. And as I mentioned, for many reasons, a great leader for all of her employees.
What about your 48% of customers receiving disconnect notice? How does that fit into the equation?
Well, as I said earlier, I'm proud of the programs that Mr. Colley lays out in his testimony, and we're working every day to find new programs. We do not, the last thing we want to do is disconnect a customer. And I think we work very hard to make that not happen.
How?
Well, through opportunities for payment plans, through opportunities to work with our billing and customer care folks to meet specific customers' needs. We have a new program teed up in this case, Payment Navigator, which provides even more particular attention to customers in need. We've worked very hard with our agencies around our service territory to provide an easier path for obtaining federal assistance, state and federal assistance. We have worked with IHCDA to set the stage for further energy efficiency measures by helping them support obtaining dollars for health and safety measures that have to be put in place before energy efficiency can be provided.
But aren't all of those, none of those help with paying your bills? It helps with, payment plans, that's required, right? The
We go
payment
beyond the requirements.
I'm sorry?
We go beyond the state requirements.
The Payment Navigator, we support it.
I appreciate that.
However, it still doesn't get to the bill assistance question. And with LIHEAP frequently being tapped out, where are we going to be able to find funds to help the customers who don't get LIHEAP assistance? And I'll stop there.
Well, we advocate certainly in a big way for federal assistance, enhancements, continuations. I think we work very well with the programs that we have available to us, both our own and federal programs. And as I mentioned, I'd be hard-pressed to find another utility that has done more to collaborate with the agencies that are responsible for getting those dollars to those customers.
But Duke still hasn't pursued any legislation to get low-income bill assistance, correct?
Ever?
Yeah, I guess ever.
I think that we have been involved in, it hasn't been in the recent past, but I've been involved in discussions when there was maybe a bit of inertia behind a similar bill that the water industry currently has in Indiana. Obviously, it wasn't pursued.
You attended field hearings in this proceeding?
3 of the 4, yes.
And you heard the testimony from ratepayers who took time out of their evenings to come speak to the struggles with current bills and the concerns about this future bill, correct?
I did. I heard certainly affordability issues. Much of what I heard from many was perhaps even a distinction between, well, around other areas of their life, for instance, rent and housing, groceries, and sort of lumping this in, which I appreciate, but I think it deserves some distinction.
You're aware of 211,
I am.
Where individuals can call in for assistance in terms of finding programs. Are you aware that utility costs are by and large, the number one
I wasn't
issue.
aware of the data. I was not.
What is an acceptable number, percentage-wise, of general residential customers to you receiving disconnect notices? What's an acceptable, affordable number?
Affordable.
What percentage would you feel comfortable with as Duke Energy Indiana president in terms of disconnect notice for general residential customers?
I've never contemplated, again, it's not our goal to disconnect customers, and I've never contemplated an acceptable percentage.
Do you believe $42 is a lot of money for a family in Indiana to provide on a monthly basis to the company?
Well, as you know, we're abiding by a new statute in Indiana that provides several priorities, right? I mentioned those earlier. In my mind, the intent of that legislation, I talked about competitiveness earlier. The affordability portion of that, in my mind, is meeting those obligations of those other four pillars at a reasonable price. And again, I think that we're doing that currently, and I think the case sets us up to continue to do that.
When you're talking about competitiveness, you're a monopoly utility. You're talking about competition between the IOUs?
Well, I think it's certainly a measuring point. It is for me. You know, I think beyond even Indiana IOUs, we're very competitive with respect to our neighboring utilities. If you survey neighboring states, maybe but for Kentucky, we're well below, Duke Energy Indiana is well below the average kilowatt hour price in those north central states.
And currently, not with this proposal. Looking at CAC exhibit, cross exhibit 1, please.
Yes, ma'am.
This document is from the Duke Energy Indiana Low-Income Collaborative coming out of the last rate case where Duke committed to work on a few issues.
Yes.
You'll see at the bottom, there it is average monthly usage by income for housing type and housing status. So looking at page 8 there, which is in the bottom right-hand corner.
I'm there.
Great. Do you see that multifamily is significantly lower in terms of average monthly usage by housing type?
Appears so, yes.
And then on the following page, page 9, this is average monthly usage per square foot by income for housing type. You see that multifamily as well is the lowest category of housing type in terms of average monthly usage.
Yes.
Would you agree this displays that multifamily households use significantly less energy and contribute far less to the peak demand?
It would appear so, yes.
As president of the company, would you agree today to at least study the issue in terms of a cost of service standpoint and whether multifamily customers should be a separate class?
Separate rate class?
Yes.
Well, I know Mr. Flick our rates expert has views on service of multifamily buildings and facilities, and he has maybe a different view than you're presenting.
Is there any harm in studying it?
Happy to have conversations around it.
Moving on to this document that has color-coded table. It's from CAC Exhibit 3.
Is it in this stack?
It might be, I can't recall, may I ask the court reporter if we provided this copy? It might be with the stack of cross exhibits.
I only received these
Okay,
two, Ms.
okay, that's fine. So the second set of testimony at the bottom of that, keep that one there, sorry. It should be CAC Exhibit 3.
Let's go off the record. Ms. Washburn, if you can get this clarified, thank you.
Thank you.
Okay, we'll go back on the record. Ms. Washburn, when you're ready.
Thank you, Your Honor. Do you understand CAC's position on how coal ash should be handled in our state?
I believe so.
That performing closure by removal, doing it once and doing it correctly, would be less expensive than the piecemeal approach that Duke has been taking? Is that generally what you understand?
I guess I understand it. I take issue with some of the descriptions.
That's fair enough. Okay. But our position has been that Duke hasn't been fully evaluating its coal ash liabilities. Is that correct?
I would assume so.
Oh, as an initial matter, Mr. Harper did talk to you about insurance settlement proceeds. Could I have you turn to your rebuttal, please, on page 6?
Page 6?
Yes, please. And at the bottom, where it's Mr. Hill's table, could you read under the second column there, just to refresh your memory about the settlement of CCR insurance claims?
You want me to read the description?
In your head, just to refresh your memory, yes.
Okay.
After reading that, do you recall that the CCR insurance claims are at issue in this case?
My understanding is that at least the company's position is that we will, once all the litigation is done, we're not done with litigation, that those proceeds would be taken up in a future ECR proceeding.
Will Duke provide the settlement proceeds to customers?
Well, we believe, due to the impairments that I mentioned earlier, that there needs to be a discussion around what portion of those proceeds would go to customers and what portion would go to the utility.
And when you're talking about impairments, you're talking about our appellate courts overturning the decision related to the coal ash case?
Those two in the current proceeding that you're well aware of, yes.
Yes.
Ms. Washburn, I just note it's 12:25. We're scheduled for a break at 12:30. I don't want to rush you, but just be cognizant of this. We're 5 minutes out, so start planning where you want to cut off. Thank you.
Yes, I'm very close. Thank you. Are you You're generally familiar with what other Duke jurisdictions do. You have conversation with your counterparts in other states.
Well, some more than others, yes.
Are you aware in South Carolina that, well, let me take a step back. Duke is not doing closure by removal in terms of removing the coal ash from the site, trying to find reuse purposes of the coal ash. Duke instead is doing closure in place where they're putting a cap on top of it. Is that your understanding?
Well, we have tried to find reuse opportunities for ash. Unfortunately, our plants are located on non-navigable rivers, which seems to be a key component to that equation. And Ms. Washburn, it's been a while since I really studied this, but I know early on in our review of coal ash basins, we did significant engineering studies related to all the basins, and we were an early starter, certainly in this space. And maybe not a majority, but a good portion of those basins were actually landfilled, where the engineering studies provided that that was the appropriate decision. Others, our engineering groups and others, technical folks, felt that closure in place was appropriate.
And you're aware that, number one, Indiana has the most coal ash ponds in the nation. Are you aware of that?
I wasn't aware of the data point.
And are you aware that most of those, a good amount of those, are Duke Energy Indiana coal ash ponds?
I don't know the proportion.
And you're aware that organizations and entities have disputed the studies that you were just referring to?
I would suspect so, yes.
Are you aware that in South Carolina, Duke Energy Progress's expert, as noted on page 53 of CAC Exhibit 3, provided extensive testimony saying that only the closure by removal approach can reliably and cost-effectively meet the CCR performance standards? Are you aware of that generally?
I'm not sure what the CCR performance standards are that you reference. I had confidence in the work of our internal teams.
Are you concerned about the discrepancy in terms of how South Carolina, North Carolina are treating their coal ash closure versus here in Indiana?
Well, we're operating under different state requirements.
The same federal law, correct?
Which at least initially allowed closure in place, as we have been doing, as well as state closure requirements.
Is Duke, would you agree that Duke has a financial motivation to piecemeal this approach wherein capital expenditures can be disaggregated and could end up costing a lot more to customers?
That has never been part of our discussion in coal ash closure programs.
What about in not pursuing securitization authorization?
Well, as I mentioned, we have not had a discussion around securitization in any kind of scenario, whether it be generation or ash.
In
Indiana.
Looking back, are you aware of the Cliffside Power Plant in North Carolina?
I've heard the name. I'm not, I've never been there. I'm not familiar with even what type of generation it is.
Are you aware that they originally had proposed or were considering an IGCC plant, and Duke in North Carolina said no, but then Indiana did it here? Are you aware of that?
It's well before my time at Duke.
Could you please confirm there are significant costs anticipated for the cleanup of contaminated groundwater, but Duke has not attempted to quantify that yet. Is that correct?
Can you be more specific?
Sure. At issue in the case, in part, is there's been significant, so looking, for example, at this table that you've been provided, which is page 5 of CAC Exhibit 3, Table 1. For Cayuga, Edwardsport, Gallagher, Gibson, Noblesville, and Wabash River, on the column under has the ash contaminated groundwater, it says yes. We still do not have an estimate from Duke in terms of the cleanup of that contaminated groundwater. Is that correct?
I am not aware.
And then we have 3 of the plants that have contaminated private wells. Do you know if we have cost projections for that?
I am not aware. Ms. Washburn, is this your table or our table?
This is ours.
Okay.
Duke received IDEM approval for a CCR plan for Gallagher. And later, EPA noted that that was not compliant. Are you aware of that?
I am.
And that was because Duke's coal ash is in contact with groundwater. Are you aware of that?
I'm not sure if it was in the present tense or a future tense, but that was an issue, yes.
And Duke has yet to reevaluate the other sites that also are in contact with groundwater. Is that correct?
That's correct. I would mention that IDEM had approved those previous plans.
Yes, IDEM approved them, and then EPA said they weren't compliant after the IDEM approval, correct?
At least for Gallagher, yes.
Coal ash contamination and cleanup is a significant issue for the communities wherein your plants are located. Would you agree?
Well, most of our generation plants, particularly coal plants, are really not near what I would call communities. There are certainly neighbors that we take great care in informing and bringing into our stakeholder discussions.
But they are, groundwater will be connected. I mean, groundwater would
Absolutely.
be connecting into the communities and into the rivers and whatnot.
Yeah, absolutely, and we're committed to, as you know, the rules require long-term groundwater monitoring, and we will be complying with that and are.
As Duke's senior management for the state of Indiana, would you commit to working with stakeholders and exploring what would be the cost of doing all in closure by removal?
Our goal is certainly to meet every federal and every state obligation related to our coal ash basins, and we're committed to doing that. When I talked about the early work that maybe delineated those basins that needed to be landfilled and those that could be closed in place, there is a customer component to that as well, with respect to cost, capital allocation and cost. And I will commit today that we will continue to follow every EPA and state regulation with respect to closure with the affordability component that's within the 5 pillars at the top of our mind.
But can Duke commit today to work with stakeholders to take a look at that together?
I think there's opportunity for that currently. As we put plans forward, certainly there is a public process associated with those plans.
There are designated, there are clearly identified organizations that are at the forefront of this issue and providing regular comments in this space and in the IDEM space and the EPA space. Will you commit to working and having a working group with those groups to do a study?
I would rather commit to fully complying with federal and state regulation in this respect and having those existing public forums that we have for that discussion.
With the caveat that we are all working towards complying with the federal law, will Duke commit to studying the all-in costs and the contamination issues?
Well, we were complying with the at least former EPA regulations, and I don't get the sense that you were pleased with where those former EPA regulations landed.
Well, I think where my client takes issue and a lot of these other organizations is, going back to Dr. Frank's chart here, that Duke's plans have been inadequate in terms of contamination. And as you've noted, the coal ash expenditures are not done and they're very large. And that's where we're trying to get some commitment from the company to work together. And it's my understanding that your answer is no.
Well, I think complying with federal and state regulation is the expectation, and those are the expectations we will meet.
May I have a moment, please?
Yes, we'll go off the record. It will go back on the record.
Thank you, Your Honor. I would move to admit what's been marked as CAC Exhibit 1 and Cross Exhibit 1 and 2, please.
Petitioner, any objection?
No objection, Your Honor.
Block? No objection. Citizens Action, City of Westfield.
No objection.
Industrial Group?
No objection.
Kroger?
No objection.
Nucor Steel?
No objection.
River Ridge Development Authority, River Ridge Property Owners Association, Rolls-Royce?
No objection.
Sierra Club? No objection from Sierra Club. Steel Dynamics?
No objection.
I would note counsel for Wabash Valley Power Association is not present. Walmart?
No objection, Your Honor.
OUCC?
No objection, Your Honor.
Ms. Washburn, can you remind me of those exhibit numbers, please?
Yes, Your Honor. CAC CX 1 and 2.
Citizen Action Coalition and CX Exhibits 1 and 2 are admitted into the record without objection. Ms. Washburn, anything further?
No, Your Honor. Thank you. Thank you, Mr. Pennegar.
Okay, the time is presently 12:37. We'll take a break for 1 hour for lunch. We'll be back by 1:40. Thank you, counsel. Okay, we'll go back on the record now, and Ms. Schultz, when you're ready with City of Westfield's cross-examination, please proceed.
Thank you, Your Honor. Westfield has no cross-examination for Mr. Pinniger.
Very well. Duke Industrial Group?
Thank you, Your Honor. We do have some questions. Good afternoon. Excuse me, Mr. Pinniger. I'm Todd Richardson, representing the Industrial Group. You know that, but for the sake of the court reporter. Can I direct your attention, please, to your direct testimony, page 16, at lines 5 to 7. You indicate there, do you not, that the company is proposing a change in its allocation methodology for purposes of the cost of service study, which will specifically benefit residential customers. Do you recall that testimony?
Yes, I see it.
Is that a reference to the switch from a 4 CP allocation to a 12 CP allocation for production and transmission investment?
It is.
Can we agree that 4 CP was the allocation that was approved in the last rate case?
We can.
Okay. What's your understanding of the purpose of a cost of service study?
Well, it's to, of course, Ms. Diaz is the expert in this area, not me, but it's to allocate the cost appropriately among the customer classes.
And is it supposed to determine the relative level of costs incurred by the company to serve a particular class?
I believe that's right.
It's a cost causation analysis. Are you familiar with that term?
Yes.
Am I correct that under Duke's proposal in this case, the base rate increase to the residential class would be about 19%? Is that right?
Yes, at the full extent of the ask, that's correct.
Okay. Was it a conscious objective on Duke's part to keep the residential increase below 20%?
It was.
Okay. And when you say that the allocation, the selection of the 12 CP allocation methodology will specifically benefit residential customers, are you indicating that the choice of methodology for cost of service was influenced by the objective of keeping the residential increase below 20%?
Well, it was part of the discussion, but as you will evaluate Ms. Diaz, she ran the appropriate tests and considered other changes beyond the models. For instance, MISO moving to a seasonal construct and other criteria for making that determination as appropriate.
But the objective of keeping the residential increase below 20%, was that part of the selection process?
Well, we wouldn't have done it if Ms. Diaz couldn't justify it.
I'll take that as a yes, that it was a consideration.
Well, I think it was, but I think the overriding issue is that she felt a 12 CP was appropriate for all the reasons I just mentioned.
Okay. Can we agree that a change in allocation methodology for the specific benefit of one rate class has the effect of shifting cost allocations to other rate classes?
Coincident peak in particular, you speaking about, or, I'm sorry?
Well, I'm referring again to your testimony that the change in allocation methodology will specifically benefit residential customers. Can we agree that what goes to the benefit of residential customers in terms of cost allocation is to the detriment of other rate classes?
That's correct.
Okay. And so the shift from 4 CP as approved in the last case to 12 CP as proposed in this case has the effect of reducing the allocation to the residential class and increasing the allocation to, say, the industrial classes. Is that
I believe that's
fair?
correct. Ms. Diaz would be able to confirm that.
We've talked about the affordability pillar today. Is it your understanding that that affordability pillar is for the specific benefit of the residential class only?
No, it's clear that it's all customer classes.
Including industrial, is that right? Mr. Pinnegar, are you aware that under current rates, the residential class is providing a return that is significantly below system average, and rate HLF in particular is providing a return that is substantially above system average? Are you aware of that?
Is that the subsidy excess issue?
It is.
Yes,
it is.
I'm aware.
Okay. So rate HLF, in other words, is providing a subsidy for other rates, and the residential rate is a subsidized rate, correct?
I believe that's correct, yes.
Okay. Do you know what Duke's proposal is in this case to reduce that level of subsidy in excess?
I believe it's 5%.
Okay. I believe that's correct. So if we put the subsidy being paid currently by rate HLF customers in monetary terms, and let's just assume that it's $100 million. It's actually more than that, but for the sake of the example, would it be correct that a 5% subsidy reduction would retain $95 million in excess in the HLF rate?
That sounds reasonable. I'm not an expert on the equation. Ms. Diaz would be.
Okay. So is it Duke's position that changing cost of service methodology in a method that increases the allocation to the industrial classes and at the same time reducing the existing excess paid by that class in the subsidized rate structure by only 5%, is it your view that that is a proper application of the affordability pillar with respect to rate HLF?
Well, again, I put stock in the work done by Ms. Diaz to justify the 12 CP. And so she's very good at what she does, and will defend that on the stand, I'm sure. So with that in mind, I think that it's an appropriate conclusion.
You think that that is an appropriate application of the affordability pillar to rate HLF? Is that correct?
Yes.
Okay. You mentioned the objective of keeping the residential increase below 20%. Is it your view that a 19% increase to the residential rate is reasonable and consistent with the affordability pillar?
Well, again, as I discussed with Ms. Washburn, I think we look at all 5 pillars, and there are expectations to be met with the other 4 pillars, as well as other priorities of the General Assembly has set forth. And again, I think that it's incumbent on the utility and for us to make the case to the Commission that our work to meet those other 4 criteria, which are equally important, is done at a reasonable cost to customers.
Okay. And you said specifically that there was an objective of keeping the residential increase below 20%. Is it your testimony that 19% is consistent with the affordability pillar with respect to the residential increase?
I believe it is with respect to the priorities, again, that we're trying to meet many priorities, both in our infrastructure space, our generation space, with our environmental compliance. And so it's incumbent on us to balance those 5 pillars in a way that I think, again, meets the other 4 pillars in a way that, in a manner in which we are providing and doing so in a reasonable fashion from a standpoint of cost.
Okay, and I understand that, but at the bottom line is you believe 19% for the residential increase satisfies the affordability criterion.
I believe it does.
Okay. other than switching cost of service methodology and limiting the subsidy excess reduction to 5%, there are other ways to keep the residential increase below 20%, are there not?
Well, there would be, yes.
For example, if the commission does not approve the full $491.5 million revenue increase being sought by Duke in this case, and instead approve something else, that would have an impact on the residential increase, would it not?
It would.
Okay. And I think you've mentioned earlier today, Duke is proposing a 10.5 ROE in this case.
That's correct.
What was the ROE approved by the commission in the last rate case?
Well, it was 9.75, and we took a 50 basis point bump due to some operational issues.
Okay, so 9.7, correct?
Correct.
Okay. In terms of measures to mitigate the rate increase, do you recall your testimony that Duke is proposing to spread the recovery for Gibson units 1 through 4 over a longer period than those units are expected to remain in service? Do you recall that?
I do, and Ms. Lilly covers that in her depreciation testimony.
Okay. And I believe you identify that as an affordability measure in your list of 8 affordability points. Is that correct?
Correct.
So in fact, it does, that extension of the recovery period mitigates the impact on customer rates, right?
It does.
Okay. Is Duke proposing that same treatment for the Edwardsport plant?
No, I think you mentioned Gibson 1 through 4.
Yes, but not, you're not following that same pattern with the Edwardsport plant, are you?
No.
Okay. Do you recall that under the 2021 IRP, the preferred portfolio anticipated that the gasification equipment at Edwardsport would be retired in 2035, but that the plant would continue to operate on natural gas through a retirement date of, I believe, 2045? Does that sound familiar?
It sounds reasonable.
Yes. And in this case, do you know, is Duke proposing to spread the recovery of the capital investment in the Edwardsport plant through 2045?
Not that I'm aware of, no.
Okay. Isn't it the case that Duke is proposing to accelerate the recovery to 2035?
Well, I am not sure.
We'll let the depreciation experts
Thank you.
Clarify that point. But if there's a proposal to accelerate the recovery of the Edwardsport investment to 2035, wouldn't the same approach used for Gibson 1 through 4 provide another mechanism for mitigating the rate increase?
Seems it would.
Okay. Thank you. So, if hypothetically the commission were to retain the same cost of service methodology approved in the last rate case, and also order a greater subsidy reduction, but the commission also decides to reduce the requested revenue increase such that the residential increase is still 19%. Would it be your view that 19% for the residential rate is a reasonable increase?
Well, that's what we have in the case now, so yes.
Okay. Thank you. No further questions.
Kurt Boehm with Kroger Company, do you have any cross?
Nothing for this witness, thank you.
Ann Becker with Nucor Steel.
Thank you, Your Honor. Good afternoon, Mr. Pinniger.
Good afternoon.
I'm Ann Becker with Nucor Steel. We have met on occasion, haven't we?
Yes, ma'am.
I will try not to repeat Mr. Richardson's questions, but I do want to pick up a theme in terms of, if we turn to your direct testimony on page 16. you talk
Excuse me,
ab-
16?
16.
Yes, ma'am.
Your revised direct,
Revised?
right?
Yes,
Line
okay.
5,
Yep.
point 4. You state here, as explained by the company witness, Ms. Diaz, the company is proposing a change in the allocation methodology for purposes of the cost of service study, which will specifically benefit residential customers. Do you see that?
I do.
Now, isn't it true that the purpose of cost allocation is to reflect the cost to serve each customer class?
Well, if that's not inconsistent with how I answered Mr. Richardson, yes.
So you would agree?
Yes, ma'am.
Thank you. And would you also agree that the cost responsibility borne by each class of customers should approximate the costs imposed by Duke to serve that particular class?
To the extent possible, yes.
You had also touched upon the affordability pillar, and you had a conversation with Mr. Richardson in that regard. You agree, don't you, that that applies to all rate classes?
Absolutely, the statute.
And are you aware that Nucor Steel is in its own rate class?
I had never heard it referred to as its own rate class, but I do understand there are particulars around Nucor, yes.
Do you understand, and I know there's testimony by other witnesses, but as you, the lead Duke witness, the concept of gradualism?
Generally,
And do you agree that the commission may authorize Duke to apply the rate-making concept of gradualism to minimize or reduce rate shock to one or more rate classes that otherwise might result with a commission order?
I'm not familiar with the precedential use of that mechanism, but it makes sense to me.
And in your experience in terms of being president of Duke Energy Indiana and your involvement with the prior rate case, would you agree that gradualism is typically applied after the costs are allocated to the respective rate classes?
After the costs are allocated. That seems reasonable to me, yes.
Thank you. I have nothing further, Your Honor.
Ms. Schultz, Ms. Wheeler, do you have cross-examination on behalf of River Ridge Development Authority, River Ridge Property Owners Association, and/or Rolls-Royce?
Yes, Your Honor. And with your permission, just for clarity, because the cross-examinations for River Ridge are unique to River Ridge, and the cross-examination exhibits for Rolls-Royce are unique to Rolls-Royce, I'd like to start clearly as asking questions on behalf of River Ridge and go through those cross-examination exhibits that I've already had marked, and then make just break for the record for a moment, and then do Rolls-Royce, if that is all right with you and with council.
I think that makes sense. And when you refer to River Ridge, are you referring to the Property Owners Association or Development Authority?
Both, Your Honor. Apologies, I meant to clarify that as well. Thank you.
Very well. Please proceed, Ms. Wheeler.
Thank you. Hello, Mr. Pinniger.
Hello, Ms. Wheeler.
Good to see you.
You also.
So in your testimony, specifically in your direct testimony, I believe you talk quite a bit about the efforts that Duke has gone through in Indiana to assist businesses looking to locate in Indiana. Is that correct?
I do, yes.
I believe you may also talk about all of the Indiana sites and buildings that are available and how Duke helps market those.
About the site readiness program?
Yes.
Are you on a particular?
I believe it starts on 34 of your direct.
I'm familiar with that program, yes.
Okay. And you have you at Duke have a site readiness database, right, that shows all of those available properties across your service territory in Indiana, is that right?
Well, I think there's two different things.
Okay.
The site readiness program is a specific program where we pick generally 3 sites a year to put some emphasis on, maybe need a bit of a kickstart. and I talk about that in my testimony. I believe we have another database of sort of general sites. They may not have been through the site readiness program, but they are in working with LEDOs and REDOs are sites that have been identified in our service territory as potential development sites.
Great. Thank you for that clarification. So I would assume with the site readiness program, there is some recognition on behalf of Duke that to get a site prepared does take some investment sometimes, correct?
Yeah, the idea behind site readiness is, again, we've worked with local and regional economic development professionals, community leaders to identify sites. And they are perhaps sites that have had trouble getting started for one reason or another. And so we provide, after identifying those sites, we provide dollars for a site selector to come in and do, I guess, what may be deemed a sort of a reverse evaluation of a particular site. We hire an engineering firm to provide advice on infrastructure, and we provide some seed money in hopes of kickstarting that particular site, and it's been a very successful program.
So if a developer or a local economic entity wants to know how much electric capacity or energy capacity and transmission capacity is available at a particular site, do they have to go to Duke to find that out if they're not an existing customer?
That's correct. That's done through our engineering group.
Okay. And are you familiar with the testimony of River Ridge Property Owners Association, or RRPOA's witnesses, Staten and Hildebrand?
I am. I responded to that in my rebuttal.
Correct. Thank you. And if you reviewed that testimony in order to respond to it, you're familiar, and I won't say the numbers aloud, but you're familiar with the attachments and the statements that are made therein about the amount of limited energy capacity and transmission capacity available for the River Ridge site?
Generally, yes. Not specific figures, but generally.
Okay. So at this point, Your Honor, I'd like to ask if the court reporter could go ahead and put the 3 exhibits that I've had marked in front of Mr. Pinniger, if I don't believe they're in front of him yet.
We'll go off the record when that's accomplished. Okay, we'll go back on the record. Ms. Wheeler?
Thank you, Your Honor. So, Mr. Pinniger, I'm going to have you look at what's been marked for identification purposes as RRPOA Cross-Examination Exhibit 1 and give you a moment to look at it. It's just 2 pages.
Okay.
Does this appear to you to be one of the reports that can be printed off Duke's database for available sites in its service territory in Indiana?
I have never looked at the database, Ms. Wheeler. It appears to have our Duke Energy logo, and it says Duke Energy at the top.
Would you like to take the time to go to that website and see what pops up, or can we agree to subject to check that website pops up this document?
I'll take your word for it.
Thank you. And are you aware that River Ridge Commerce Center is in fact a potential site for new economic development in Indiana, that it's in Duke's territory?
Absolutely. We've worked for many years with River Ridge.
Great.
Collaboratively.
And you'll see under property details in the left-hand column, the minimum size of potential economic development projects. They could get a parcel of 3 acres or a parcel of 2,561 acres, correct?
That's correct.
All right. And if you'll flip on the other side, or I'm sorry, flip on second page.
Yes.
And I will submit to you, sir, that there are very many resources available on this database, and you could click on attachments related to River Ridge, and I did not attempt to print all of that information out. These are just the first 2 pages that are available. But if you'll see in the left-hand column on the second page, you can click on all of that information, and I just wanted to make clear to you that I didn't attempt to represent to you that every document available for River Ridge Commerce Center is in front of you. Does that make sense?
Yes, understood.
Okay, so now I'm going to turn your attention to the right-hand column under description. Can you see there the 3 bullet points?
I see that.
Do you see there where it says 100 megawatts available today at River Ridge Commerce Center?
I see that.
That's not the right number, is it?
I don't believe so.
In fact, if we were to go back to River Ridge POA's testimony, it is a much, much smaller number. Can we agree on that?
Yes, with the recent development, certainly within the last 2.5 years, I don't know when this document was updated by River Ridge or Duke Energy, but that's the case. You're right.
So at this point, if subject to check, we've agreed that this is what's on Duke's website today. Duke is representing to the public that there's 100 megawatts available at River Ridge Economic Development Commerce Center for economic development, right?
It appears that to be the case, yes.
Thank you. Can we agree that economic development projects are highly sensitive to electric rates?
Yes.
So isn't it also true that businesses will quickly eliminate site selection areas where certain key factors that they want for their project don't exist?
What was the tail end of your question?
Isn't it true that businesses will quickly eliminate areas for economic development projects when certain key components that they are looking for do not exist?
Well, that doesn't necessarily happen quickly, but it can happen certainly along the process in my experience for various reasons.
So if a project wanted to come to River Ridge Commerce Center and they approached IEDC, the Indiana Economic Development Corporation, and Duke and said, hey, I see there's 100 megawatts available at River Ridge, that's my minimum. They're going to get told that's not available, right?
Not necessarily. In my experience, these projects depend on a variety of factors, as you mentioned, but very important is the ramp schedule that a particular site has. And we have, as you know, worked through those issues at River Ridge, I think in a productive fashion. And as I expressed in my rebuttal testimony, we now have a reason to build substantial transmission and capacity at River Ridge.
But that's not coming for 5 years, and that's not a confidential number, is it?
The years?
Right.
Well, 5 years is not set in stone. They never are. Our engineers work as quickly as possible to provide the generation that is requested on the ramp schedules that are needed. Normally, that ramp schedule is a bit of a negotiation, particularly in these times when we know big economic development projects are the norm across our service territory and across Indiana. So it takes a collaborative effort to not only build the transmission, which we will do, but also figure out appropriate ramp schedules for the new customer.
So if a new customer at River Ridge wanted to be operational at 100 megawatts in 1 year, could Duke meet that ramp schedule?
That wouldn't be possible.
How about 2 years?
I suspect not.
How about 3 years?
Possibly.
Possibly. But your current plan is 5, right?
Well, there are a lot of factors at play here, one of which is the retention of property rights to build transmission, which the transmission we have planned and have discussed with River Ridge actually is 2 major lines. We'll use existing easements or rights of way to the extent possible, but we know that at least one of those lines will require property negotiations with owners. And so that is an element of the schedule that many times becomes an issue.
And what is the timeline for the upgrades that you just mentioned?
Well, I'm not specifically sure what timelines we have provided River Ridge, but I know I've been in enough of these projects to know that our engineers never overpromise and do their darndest to overproduce with respect to timing.
Could we look at the your rebuttal testimony? I believe you've got an attachment there where you've laid out some previous economic development projects at River Ridge. It would be, I think, the last page of your testimony.
Yes, Ms. Wheeler.
Okay, thank you. And just for the record, that's attachment 28A SCP. So when I look at these economic development announcements at River Ridge, these are for 2014 to 2024, right?
Yes.
And in that time, you have 27 projects listed, right?
Here so, yes.
So if you've got 27 projects listed in your own table that occurred in the last 10 years at River Ridge, doesn't it not make any sense to you that Duke would assume that the remaining projects at River Ridge to build out thousands more acres that are available aren't going to need any additional transmission until 5 years from now?
Well, we hear that a lot in 69 counties that we serve. And we have been consistent on this, Ms. Wheeler. I've been chewed out many times in this respect. We just do not feel that we can invest in this, for instance, in this case, well over $100 million in new transmission until we have a customer committed to serve, which did happen during the course of this case, as you're aware. Block provided a notice to proceed, which we are doing.
So let's talk about what your standard is. A customer committed to proceed is what you said. What does that mean?
That's a great question, a timely question that a lot of people are asking right now, given the growth that's happening in Indiana. In our view, it's not a ribbon cutting. We have experienced ribbon cuttings that did not proceed. It is beyond that when we have negotiated site agreements and electric service agreements.
So it has to be signed on the dotted line with Duke as an electric service agreement or customer
Well,
agreement?
it does, and it makes sense because in many of these cases, there is a sharing based on the prospective customer's portion of the transmission build-out that they will be responsible for. And we need committed megawatts. Frankly, we need a customer to serve, particularly in instances where we're talking about hundreds of millions of dollars and the procurement of property rights to build the transmission.
So when you, let me just state for the record, we certainly are pleased that Block is here, and we have no hard feelings with Block and are glad they're coming to Indiana. But that said, you and I can agree that Block pretty much took up all of what was left in the area in terms of available energy capacity and transmission capacity, right?
Well, there were many projects, as you can see, just in 2024 that came to fruition, big projects. And so it wasn't just Block. You can read the list yourself, and others can as well. Particularly in the last 2 years, that capacity was called for.
Do you know how much capacity it was?
I don't off the top of my head, not on this chart.
So did you have signed electric service agreements with everyone who took up that extra capacity before you built it?
I believe so. With respect, well, the other element of this is a filing of a TED here at the commission, which is available under the TDIS statute, which allows consideration of, as you're aware, infrastructure associated with these economic development projects. That's an important part of the process because the commission not only weighs in, but the IEDC does as well in those proceedings. And we do that when we have certainty of the need to build to serve customer.
But if you had extra capacity to start with, sir, how did that happen if you did not yet have an electric service agreement signed? If that's the
talking about with
requirement, how
Block?
did you have so much extra to start with?
Well, this was capacity that was available to River Ridge, as I understand it. We did file a TED related to Block. We had been working with Block for 5 years, substantial amount of time, and we were at a point where we felt certain they were going to locate at River Ridge.
But that was fairly recent that you filed that agreement with the commission, right? This year, I
Early
believe?
this year.
Okay. So transmission capacity and generation capacity doesn't materialize in a year. It had to have existed before your Block deal was signed, right?
Well, I'm not saying we didn't have capacity at River Ridge. Obviously, we're serving the customers that are listed here, if that's the implication.
And if those customers didn't have a signed agreement with you, how was their capacity available if that's your threshold requirement?
Well, I presume other than the TED that was filed this year, I would have to check, Ms. Wheeler, that we had sufficient capacity on the ground at River Ridge.
Do you see the chicken and the egg problem, Mr. Penninger?
I do, but I see it well beyond River Ridge, and it's a policy decision that I think is relevant from the standpoint of all of this economic development, not only the committed projects, but the proposed projects. Our pipeline currently is substantial, dozens of projects, and we can't look at that list and presume that we're going, and we know we're not, but we can't look at that list and presume we're going to have 50 different new customers and plan for that right away.
Do you plan for it at all? I'm sorry,
Sorry?
were you done?
I said it wouldn't be practical from the standpoint of capital allocation. It wouldn't be prudent with respect to the impact on general customer rates, it wouldn't, we feel, and again, this has happened beyond River Ridge, where we've had different folks insisting we build transmission to serve a prospect that had not been committed to a site. And we have not done so.
So my question is, have you, Duke, in the past, planned transmission and generation upgrades based on forecasted economic development growth that had not yet materialized?
I'm not aware. When we forecast growth, it is, and this is in Mr. Abbott's testimony, when we forecast growth, it is more along the lines of substation upgrades that have to be made due to, generally this is in mostly the suburban counties of Indianapolis, when homes, commercial development is happening right under our nose. And generally speaking, those substations are beyond capacity or nearing their capacity. And so we know in those instances that the capacity has to be upgraded on a quicker basis.
So it's Duke that makes the call on that, right?
Well, I think we're good at it.
I'll hold back my comment on that. So I'm going to move on a little bit on to the CX RRPOA cross-examination Exhibit 2. It is actually RRPOA's responses to Duke's data request number 2. Have you seen this data request before?
I have not.
I'm going to draw your attention to data request response 2-1.
Okay.
There, the question is, please refer to page 3 of Mr. Hildenbrand's testimony. Explain the basis of the statement regarding, quote, repeated failures to commit to provide sufficient electric service. And I think there's supposed to be an end quote there. You see that question?
I do.
And then the response refers to Mr. Staton's testimony at pages 8 through 12 and Mr. Hildenbrand's testimony at pages 7 through 10. And then he said that the response says, just since January 1, 2024, the request for information received by the River Ridge Development Authority from projects interested in siting at the River Ridge Commerce Center and based on information provided by Duke Energy on July 8th, 2024. Duke Energy has insufficient ability to serve 24% of the projects on the requested timeline and is unable to serve 33% of the projects if the off-taker was unable to take service at a higher than normal voltage using an interim tap. You see that?
I do.
So let me make a few clarifying questions first. One, a request for information is known as an RFI, right?
I think so.
Okay, so I'm just going to use that abbreviation. So an RFI would be something, in your experience, that a company who's interested in an economic development project might issue to try to get a sense of what sites might fit their needs. Is that right?
I have not been involved in the RFI process, but that sounds reasonable to me, Ms. Wheeler.
Okay. Are you aware that IEDC will sometimes send RFI information to your staff at Duke, Indiana?
I am.
You are?
I am.
Okay, thank you. Sorry, you were a little far away from the microphone. So generally speaking, you're familiar with that process where IEDC is trying to confirm the available electric energy and transmission capacity available from Duke.
Yes, ma'am.
Thank you. So This also says on July 8th, Duke provided information about what was available from the 2 lines serving River Ridge. That's also in River Ridge's testimony. Do you recall that?
Can you reference again the specific?
So in Mr., and if we need to go in camera, we can do that and pull out, or I can put the testimony in front of you and ask the court reporter to do it. But it's the line of communication via email that was in an attachment to the River Ridge testimony, where they were asking very specific questions of your economic development staff at Duke in July of this year, trying to determine how much energy and transmission capacity at Duke was actually available for new economic development projects. You remember that?
Yes.
So would you agree with me that the first time in that email that Duke told River Ridge how little capacity for energy and transmission was actually available was on July 8th of this year?
I wouldn't be able to pinpoint a time. I know that many of us had discussions with River Ridge on various projects where these new transmission lines were discussed specifically, and timelines, and the specific need to build those lines when certain capacity limits were met. And that would have been late last year.
Did you make anyone at River Ridge aware that you were negotiating a deal that would take up most of the existing transmission and energy capacity that was available that you'd been talking with them about?
Well, I certainly didn't. I can't speak for our economic development team. I guess I may be naive, but I would think River Ridge would have been aware of the prospect of Block and Canadian Solar and the others. I don't know how that works.
So let me ask you this then, in an area in which I think you're more familiar. Isn't it true that the agreements that Duke has filed with the commission, for example, with Block, are confidential and not subject to public disclosure?
Yes, I'm aware of that.
So isn't it true that even if River Ridge knew that Block and Canadian Solar were interested in building projects in the area, they would not have known the total energy capacity and transmission uptake essentially those projects would have made, because that's confidential information for Duke, right?
Well, it is for us. I have no way of knowing what Block shared with River Ridge.
Do you have any reason to believe that Block did share that information?
I have no idea.
Are you aware that Block objected to River Ridge's request for a copy of that contract in this case?
I am.
Are you aware that the commission essentially upheld that objection and it wasn't provided?
I thought it was provided. Maybe I'm mixed up, but
I believe it was provided perhaps to others.
Okay.
It was not provided to River Ridge.
well, you just educated me on who it was provided to. So
I believe that's accurate.
Okay.
But that's okay. It would be, in other words, something that River Ridge would have to get, specifically ask for, and either Duke or the affected customer would have to agree to provide, right?
Makes sense.
Or the commission would have to order a party to provide it, right?
Yes.
It's not something that River Ridge could just go out there and find on their own, right?
Not publicly, no.
Thank you. That was just my point. Thank you. I appreciate that. So can we agree that it doesn't matter how much electric generation capacity is in Duke's portfolio or that they buy from the market if Duke doesn't have sufficient transmission capacity to deliver that energy to a customer?
To serve a particular customer?
Correct.
Yes, transmission, particularly for larger loads that I presume we're inferring here, yes.
So even if a customer has a special contract that allows them to go out to the market to purchase capacity, if there's not sufficient transmission there to deliver that capacity from the market, it doesn't really matter, does it?
I'm going to interpose an objection at this point because I believe that mischaracterizes the nature of the contract between Block and Duke, which has been approved by the commission and is described accurately in the commission's order.
Ms. Wheeler?
Your Honor, I didn't say a word about Block.
Ms. Rampala?
The entire line of questioning so far has been with respect to Block, whose name has appeared repeatedly again and again. And everyone in this hearing room knows that there has been a recent order approving a contract between Block and Duke Energy.
Ms. Wheeler, restate your question, please.
Sure, Your Honor. Mr. Pinniger, if any customer of Duke's has a special contract that allows them to go out to the market and there is not sufficient transmission capacity to deliver the energy that the customer wants, the ability to go out to the market doesn't necessarily matter, does it?
I believe that would be the case unless there was an opportunity for on-site generation.
Thank you. Do you remember your, what you mentioned a few moments ago, and time is slipping, so I don't know whether it was 5 minutes ago or 20 minutes ago, when you were talking about the bulk transmission line upgrades that Duke had planned?
At River Ridge?
At River Ridge, yes.
Yes.
Are you aware of the fact that new technology developments in transmission lines can mean that upgrades can happen on existing transmission lines that are more efficient due to the new technology that's used?
Well, I see different theories on better efficiency in a lot of respects. I really do not delve into those areas. We have a robust transmission and engineering team that I trust to follow those issues and decide what is the best investment.
But are you aware that you can use a new kind of metal in a bulk transmission line that doesn't have the amount of line losses that the current aluminum wires have?
I've not read specifically regarding that technology.
That's fair. Are you familiar with FERC's new transmission and cost allocation rule that came out in May? Are you generally aware of it?
Vaguely, yes.
Okay, I think it's generally referred to FERC Order Number 1920. Does that ring any bells with you?
Yes.
Thank you. So in that, are you aware that in that new rule, some of the major elements are that utilities are going to need to anticipate future needs in 20-year transmission plans?
I wasn't aware of the timeframes, no.
But you were aware that utilities like Duke were going to need to anticipate future transmission needs?
Sure.
So doesn't that in itself, if FERC is asking utilities to estimate if let me restate the question. I apologize. I'll withdraw it. My question is, Mr. Pinniger, if FERC is asking utilities in its new rule to estimate future transmission needs, isn't that in of itself a little bit speculative?
Well, I believe that order is perhaps a little more oriented towards moving power more efficiently to the east from the west, where renewables are more prevalent and more efficient. I have nothing against future transmission planning. I think as I mentioned earlier, it's a matter of ensuring that you're building future transmission to serve a real customer.
So, assuming subject to check that I'm correct, that FERC's Order 1920 is a 20-year transmission plan, do you think FERC intends that you at Duke have a signed customer in order to do those estimates of new transmission need?
Object, Your Honor. This line of questioning calls for speculation and is outside the scope of this case with respect to the FERC order.
Ms. Wheeler?
Your Honor, Mr. Pinniger in his rebuttal talks about T-DISC. He also talked about it with Mr. Harper in his rebuttal. It's pages 32 and 33. If Mr. Pinniger has opened the door to talk about transmission distribution system improvements, I think the new FERC rule that Duke's going to have to comply with is fair game.
The objection is sustained as to Mr. Pinniger's belief as to what FERC's. Ms. Lockhart, reread the question, please. Okay, the objection is sustained as to the witness's belief as to what FERC intended in passing this order. Ms. Wheeler, please continue.
Thank you, Your Honor. Mr. Pinniger, you're an attorney, right?
Well, I am. I have a law degree. I haven't practiced since 1994, so I'm not sure. I can read a statute, I believe. Can't write a brief.
Oh, I'm not sure I agree. I think you might have skills in that area, but I understand that you're not practicing as an attorney, nor have you.
Ms. Wheeler, what's your question?
I'm sorry?
Please proceed with the question.
Thank you, Your Honor. Are you familiar with the Hope and Bluefield cases from the U.S. Supreme Court on utility rates?
I believe Mr. McKenzie refers to those cases in his testimony, but I'm not familiar with them.
Have you heard the term regulatory compact?
Yes.
What does that term mean to you?
Well, in return for just and reasonable service, the utility to its customer base, a utility has a right to a fair and reasonable return on that investment.
And what is the customer side of that compact? You talked about the utility side. Is there a customer side?
I think it's just and reasonable service.
How about best and most efficient service?
If that's, you're the practicing lawyer.
Thank you. Have you, are you familiar with Indiana Code 8124?
Can you give me a reference, please?
It references a utility's requirement to provide, quote, reasonably adequate service, end quote.
Okay.
You've heard of that?
Yes.
Okay. So Do you agree with the regulatory compact as you described it?
Do I agree with it?
Mm-hmm.
Certainly.
So I'm going to go back to the T-DISC issues that you talked about with Mr. Harper. You said you were familiar with the T-DISC statute, right?
Yes, generally.
And you were a witness in Duke's latest T-DISC 1 and 2 cases, right? Did you
Not
say
in
that?
one. In
I'm
two.
sorry?
Not in one, I was in two.
Okay, thank you for that clarification. Your current 7-year plan, I believe that you have,
Six-year plan.
I'm sorry, 6-year plan, you're correct. It's 2022 to 2028? Yes, thank you. So isn't a 7-year plan in and of itself speculative?
No, not at all. We have focused both in TDISC 1 and TDISC 2 on reliability upgrades. And I wouldn't view reliability as speculative.
Did Duke require every customer that's going to be served by the transmission upgrades in your 6-year plan to have an electric service agreement?
No.
Isn't it true that you could get to year 4 of your 6-year plan and there isn't enough pre-approved money left to finish it?
Pre-approved money from the commission?
Correct.
Approved?
Sorry, I didn't phrase that well, but yes.
No, those plans are, if you've seen a TDIS plan that's been filed, very specific with respect to projects and varying classes of estimates related to those projects. There's a contingency that is provided as well for unforeseen circumstances related to putting those projects into service, but you know, we plan our capital appropriately with respect to the TDIS plan that's been filed and approved by the commission.
That's fine, but I'm not sure you answered my question. Let me try to ask it better. Let's say, and I'm not going to use the real number because I believe it's confidential, but let's say your current 6-year TDISC plan has expenditures of $100 million over the 6 years. You with me?
I am.
So if in year 4, because of inflation or other reasons, you get to $100 million earlier than expected, is Duke done?
No, it's my understanding that that's what the contingency that's built into the TDIS plan is specifically meant to address.
So if the contingency includes $100 million, in my example, in year 4, you reach $100 million, including the contingency. The projects in years 5 and 6 don't happen as planned, right? Because there's no additional approved money for them, right?
Objection, Your Honor. Ms. Wheeler's question goes outside the scope of Mr. Pinniger's testimony and outside the scope of this proceeding, particularly with respect to years beyond the forecasted test period of which she refers to in her example.
Ms. Wheeler?
Your Honor, we're not talking about the test period. We're talking about the TDISC plan that Mr. Pinniger spoke to in his own testimony. And as the commission is well aware, I believe what I am describing is exactly what happened to Duke, or I'm sorry, to NIPSCO. They didn't finish their last TDISC plan and had to start again because they ran out of pre-approved investment under the 80%.
Ms. Steffes?
Your Honor, that delves into the specifics of the approved TDISC plan and is outside the scope of this rate case proceeding.
The objection is sustained. Ms. Wheeler, move on.
Thank you, Your Honor. Mr. Pinniger, what happens if a project is not in the 7-year plan?
If a project is not in the 7-year plan,
Yes.
Objection, Your Honor. This line of questioning is continuing down the same path.
Ms. Wheeler?
I may be wrong, Your Honor, but I believe that petitioner is proposing to roll in some of the TDISC costs that it's already included in this case into base rates, and I believe this is fair game.
Ms. Steffes?
Your Honor, the commission has approved the TDISC plan.
Ms. Wheeler, restate your argument that you just stated to me, please.
Your Honor, I believe since the TDISC plan began in 2022, that petitioner is attempting to roll in the remainder of the investments, the 20% that it already incurred, into base rates. I may be wrong, but I believe that is what they are asking for.
And Ms. Steffes, any follow-up on that statement? Thank you for the clarification.
I believe that Ms. Wheeler's line of questioning is very hypothetical and calls for speculation.
It is hypothetical. I think the witness may answer the question to the extent he's able, is within his scope of knowledge. Objections overruled.
Thank you, Your Honor.
after that, would you mind repeating the question, please, or have it get read back? I appreciate it.
Thank you. Madam Court Reporter, would you mind? I'm getting old as well.
A. Well, as we budget, we have certainly, I mentioned our capital planning for TDISC. And we're committed to those capital plans, I suppose, unless we would do what, I'm not familiar with the NIPSCO case. We have base capital allocated to transmission and distribution. And the TED projects that we have had has been incremental capital to our plan up to now. So with respect to TDISC, I don't foresee a scenario where we're going to run out of capital over the course of the plan necessarily. Things change, right, over the course of 6 years. But if it's not in the TDISC plan, we depend on base capital or incremental capital, mainly attributed to TED projects.
Is it your understanding that Duke can change the order that it had originally indicated to the commission that it would do projects? Is there some flexibility there?
Well, I'm not an expert at this, but I think at the end of each calendar year, we provide an update to the commission on projects we intend to pursue in the following year.
And that list is up to Duke?
I believe that's correct. I'm not sure of the process.
Okay. Now I'm going to refresh your recollection. Do you recall the request in River Ridge's testimony for Duke to make a generalized tariff available for special contracts?
I do.
Does Duke market the availability of special contracts as an option for its customers?
No, we market our rider, which is generous and popular, Economic Development Rider 58. But what we have found with respect to, and I think there's maybe a bit of a misnomer here. There's not many special contracts in our portfolio. They are customers that have special attributes about them, whether it be generation requirements that they have. Some are cogeneration facilities. Some are substantial load modifying resources. And so it's literally a handful of customers.
So Do the customers with special contracts have to meet all the requirements of the economic development rider?
No, they're not linked.
They are not linked.
Not linked.
So it's two completely different things, right?
That's right.
So if you don't market it and it's not in Duke's tariff, a customer is not going to know that a special contract is an option, right?
Well, after this case, they will. No, more seriously, the statute, as I discussed in my rebuttal, the statute is permissive, and it requires commission approval. And there are attributes that we recognize as we're talking to prospects where they may make sense.
But there are not, that you're aware of, any specific characteristics or criteria that Duke has for a customer to qualify for a special contract, right?
Not in any kind of tariff or publicly written scenario, no. I think, our rates group has a sense of when it may be a fit based on those attributes that I spoke about earlier that, just generally don't fit with a customer that has sort of more normal customer attributes.
Is there a certain amount of investment that has to happen to qualify for a special contract?
No.
Is there a certain level of power usage?
Well, there can be. I talked about significant load modifying resources that are very helpful, but generally no.
Is there a certain number of jobs that have to be created?
No.
Are special contracts only available to large industrial customers?
No. I mentioned in my list of attributes, some are co-generators.
Could a municipality qualify for a special contract?
That wouldn't, in my mind, I'm not the expert on these. I hear about general discussions, but in my mind, a municipality would be a tough fit for a special contract.
How about a big box retailer?
Same.
How about a large hospital?
Same.
So, are you generally familiar with the TDIS statute?
Generally.
Are you aware that 813911C says that a utility can require a deposit or, quote, other adequate assurance from a developer or any local, regional, or state economic development organization if it's concerned that there is not enough payback under a 20-year term for the investment?
I'm familiar with the concept. I'm not familiar with the statute.
Okay. So are you aware of any Duke customers that have, under the TDIS statute, been asked to provide a deposit or other adequate assurance for a TDISC project?
TDIS projects are not, they're not customer specific unless there is a reliability issue that's been noted and needs to be addressed and has been included in the filed plan.
Aren't the TED projects in your TDIS customer specific?
I'm sorry.
Objection, Your Honor, to the extent that disclosure of whether or not any particular TED project within Duke's TDSIC portfolio has required or not required a deposit could lead to the disclosure of confidential information at a time when we are not in camera and before parties who do not have any agreements with several individual companies here that would have special contracts.
Ms. Wheeler?
Your Honor, I think he already answered the question I asked before the objection was raised.
To the extent the question has not been answered, the objection is sustained.
Thank you, Your Honor.
Ms. Wheeler,
Ms. Wheeler, I would note we're 5 minutes out to our next scheduled break, so please plan accordingly. Thank you.
Thank you.
Ms. Wheeler, can I address my answer?
Your Honor, there isn't a question pending before the witness.
Mr. Pinniger, wait till the next question is asked, please. Thank you.
Yes, Your Honor.
Thank you. If River Ridge offered to bear some of the cost for transmission upgrades at River Ridge, would Duke be willing to talk about that?
We certainly, Ms. Wheeler, the relationship with River Ridge has been robust up until the last few months. And I expect it will certainly continue. We're always willing to have discussions with River Ridge.
So was that a yes? You'd be willing to talk about it?
We'd be happy to talk.
Would you be willing to send your staff with authority to talk about it with River Ridge?
Well, I have great confidence in our economic development team, and we would have to, we'd have to come back and have a discussion around the proposal. As I mentioned earlier, we're committed to building substantial new capacity to serve River Ridge.
So let's turn your attention to what's been marked for identification purposes as RRPOA CX3. It is an email.
Yes, ma'am.
Okay, I'm going to give you a chance to look at that, and it may be easiest if you begin on the third page with the first email in the chain from Wendy Dant Chesser at River Ridge.
We'll go off the record while the witness is reviewing that. Mr. Pinniger, let me know when you're ready. Thank you.
Thank you, Your Honor.
Thank you. I've perused the document, Ms. Wheeler.
All right, we'll go.
Your Honor.
Thank you, Mr. Pinniger. Mr. Pinniger we'll go back on the record. Mr. Pinniger has had the opportunity to review the exhibit. Ms. Wheeler, please proceed.
Thank you, Your Honor. Mr. Pinniger, were you aware that River Ridge had asked to meet with you during the pendency of this case this summer?
I saw the first email. I did not see the subsequent emails. The first email being at the end of the chain.
The one from Wendy Dant Chesser?
Yes, ma'am.
Asking to meet with you
Correct.
about what was happening, and that never happened, right?
That's right.
Were you aware your counsel refused that meeting during the
Objection, Your
pendency of the
Honor.
case?
This is asking Mr. Pinniger to divulge attorney-client privileged information.
Ms. Wheeler?
I'm sorry, who made the objection?
Ms. Hennigan, who wrote the email that you've put in front of Mr. Pinniger.
Is that, I can't see, I'm sorry, Your Honor. Is Ms. Hennigan talking? Do we have more than one attorney, Your Honor, that's allowed to make objections in our cases now?
We're going to take a break for 15 minutes. The time is 3 o'clock. We'll reconvene at 3:15. Thank you, counsel.
Thank you.
Now we'll go back on the record. We're streaming again. Ms. Steffes, on behalf of Duke, I believe Duke has an objection to a question that Ms. Wheeler has raised. Before I get to your objection, Ms. Wheeler, if you would, please restate your question. And then Duke, let me hear your objection and argument. Thank you.
Due to the break, Your Honor, I may need the court reporter to reread the question, please.
Okay, Ms. Lockhart, when you have a moment, please. Thank you. All right, Ms. Steffes, I believe Duke had an objection. Is that correct?
That is correct, Your Honor. Ms. Wheeler's question delves into privileged information, attorney-client, protected by the attorney-client privilege.
Ms. Wheeler?
Your Honor, this is an email between counsel. It is not a privileged email. I only asked if he knew about it. I am not intending to ask, nor do I want him to reveal any conversations that he had with his counsel, and he has already stated for the record that the meeting didn't happen.
And so your question, Ms. Pinniger, I just want to make sure I understand correctly, is he aware of this email? Is that correct?
Correct,
Okay,
because he could have been blind carbon copied for all I know.
Mr. Pinniger, you may answer that question, and with that, Ms. Wheeler, then proceed.
I believe, as I stated earlier, I was familiar with the email, the initial email from Ms. Chesser to Ms. Schneider, and I was not privy to the subsequent correspondence.
Is it your opinion that telling a customer who wants to meet with Duke no is a good idea?
Well, it's complicated right now. Certainly, we met with River Ridge regularly before litigation, but I know that on advice of counsel, this decision was made. As we saw intervener testimony and email and other correspondence that was included in that testimony from a meeting that happened just days prior to the filing of the intervener's testimony.
So I'm going to try to cut to the chase.
Sure.
If I represented to you that River Ridge just received another RFI from IEDC yesterday that has an interest in significant capacity, and all River Ridge wants to do is talk to the people at Duke, then can help solve their problems, would you, sir, as president, commit to meeting with them immediately?
Objection, Your Honor. Ms. Wheeler mischaracterizes. The advice was merely that an attorney be present while litigation was pending.
I'm sorry, restate that, Ms. Steffes.
The email reflects that the advice is that an attorney be present during conversations. Ms. Wheeler mischaracterizes.
Overruled. Ms. Wheeler, please proceed.
So, Your Honor, you want me to respond?
Sure. Yes, go ahead.
I mean, it clearly says at the top of the first page, Duke prefers these conversations to take place once the rate case concludes. It doesn't say it can happen among counsel. That's what the July 24th email says.
Your question, Ms. Pinniger, is merely will the company commit?
Ms. Wheeler, sorry, you said it twice. I don't want anyone to get the wrong idea.
Thank you. And your question is merely will the company commit to conducting such a meeting?
Immediately, yes, sir.
Okay, Ms. Pinniger.
I feel that I need legal advice before committing, no disrespect, certainly. I feel like given we're in the middle of litigation and what we saw in the intervener testimony, which was obviously fair game, but it was correspondence and data that happened just prior to the filing, that I need legal counsel to better understand how to approach River Ridge. It's my understanding that in this interim period, our economic development folks have been working through One Southern Indiana on similar RFI activity. I may be wrong, but that's my understanding.
So Are you aware of whether Duke has spoken to other parties to this proceeding during the pendency of this rate case outside formal proceedings?
I'm trying to think if I have. I have not.
I didn't ask if you were present. I asked
I'm
if
not
you are aware of representatives from Duke speaking to other parties
not
about
aware.
this case.
Not aware.
You are not aware. Okay. Have you, in any previous Duke case where a party presented pre-filed testimony that perhaps Duke Corporate did not like or appreciate, refused to speak with them during the pendency of the case?
In my own situation? You're referring to my own?
Are you aware of this ever happening before, sir?
I'm not.
Is it your position that if a party feels like they can't get an answer from Duke on an issue and they need to intervene, that means that all communication should cease?
I would think generally not. I need to talk to my lawyers.
What was it that was so upsetting to you that you would not want to speak to River Ridge?
I didn't make this decision, Ms. Wheeler. It was based upon advice of counsel.
Okay, fair. Have you ever had, never mind, we won't go there. If your counsel advises that you may meet with counsel, not asking for meetings without counsel, sure, counsel can be there. If you were given advice by counsel to go ahead and meet during the pendency of this case, presumably after the hearings are over, but before a final order, would you do so?
With counsel?
With counsel, sir.
Again, Ms. Wheeler, I would be inclined to do so with counsel, but I am not counsel. They're sitting at the end of the table, so I would need their advice.
Sure. So is that a yes, pending advice of counsel?
Objection, Your Honor. Mr. Pinniger has addressed Ms. Wheeler's question.
Sustained.
Thank you, Your Honor. Your Honor, if I may have a moment, please.
We'll go off the record.
Your Honor, that's...
We'll go back on the record.
I'm done, thank you. Your Honor, I'm done with the River Ridge related questions, if I may transition. Oh, I'm sorry, I need to offer my exhibits. At this time, River Ridge POA would like to offer what's been marked as RRPOA cross-examination exhibits 1 through 3.
All right, petitioner, any objection?
Yes, Your Honor. Petitioner objects to the admission of RRPOA Cross Exhibit 1. It has not been authenticated nor a foundation laid. Mr. Pinniger testified that he has not seen this document. There's no date of access that this document was produced, and for that reason, we object to its admission. We also object to the admission of RRPOA Cross Exhibit 2. These are data requests responded to by River Ridge. Mr. Pinniger was not the sponsoring witness to these data requests, nor was he familiar, nor was he testified that he was not familiar with this document.
So no foundation is your objection?
Correct. And then with respect to RRPOA Cross Exhibit 3, it has not been authenticated and the foundation has not been laid. Mr. Pinniger testified that he was only familiar with the first email of the email string, not subsequent emails. I would also note that on Ms. Schultz' July 17th email, it looks like there is a portion of that email that is not fully has not been fully replicated. And to the extent that it is admitted, it contains confidential information on page 3 with respect to available capacity.
Mr. Rampala with block. Any objections?
No specific objections, Your Honor, no.
Ms. Washburn, Citizens Action Coalition.
No objection, thank you.
Ms. Schultz, does City of Westfield have any objections?
No, Your Honor.
Mr. Richardson, Duke Industrial Group.
No objection, Your Honor.
Mr. Boehm with the Kroger Company. Ms. Becker with Nucor Steel.
No objection, Your Honor.
Mr. Smith with Sierra Club. Sierra Club has no objection. Steel Dynamics, Mr. Clayton, I believe he's actually left for the afternoon. As has Ms. Zacola with Wabash Valley Power Association. Mr. Nam with Walmart.
Walmart has no objections, Your Honor.
Mr. Harper, OECC.
No objection, Your Honor.
All right, Ms. Wheeler, what is your response to Duke's objections as to lack of foundation on all three?
Your Honor, on CX1, I offered Mr. Pinnaker an opportunity to go to the website himself and look at it and take the time to do that. I don't think it's reasonable for him to know, or for us to expect him to know every single page of thousands of pages of information. He did say he was generally aware of the database and what it contained with regard to economic development sites in the Duke territory, so I think it's fair game. On CX2, I also think River Ridge POA's responses to Duke's own data request is fair game, and if the commission determines there isn't a foundation, I would ask that counsel be asked by the bench to identify which witness would be the proper one to talk about that, who is familiar with this response to Duke's own questions. I don't think Duke should be permitted to hide the ball on the responses to its own questions in discovery. As to CX3, Mr. Pinnaker did testify that he was familiar with the first one and that subsequently no meeting that was requested with him actually ever occurred. I think that's a sufficient foundation. Thank you.
All right, in terms of cross-examination, RRPOA cross-examination Exhibit 1, Mr. Pinnaker was asked a fair number of questions regarding the exhibit, the contents of the exhibit. As such, the objection is ill-timed. None of those questions were objected to at the time prior to its admission. RRPO1 cross-examination Exhibit 1 is admitted. If I understand, if I remember correctly, cross-examination Exhibit 2 were data responses exchanged in discovery. Is that correct? All right, that exhibit is admitted as well. In terms of RRPOA 3, Mr. Pinnaker indicated a familiarity with the first email, which is dated July 16th from Wendy Chesser to, from Aaron Schneider to Wendy Chesser. Is that correct? Okay. He expressed no knowledge regarding the other emails attached to that document. As such, the exhibit is admitted as in regards to the July 16th, 2024 email from Wendy Chesser to Aaron Schneider only. Council tomorrow bring a updated version of this email chain that includes only the admitted email. Ms. Wheeler, please proceed.
Thank you, Your Honor, and we will take care of that tomorrow. Appreciate it.
And in case I didn't say it, RRPOA cross-examination Exhibits 1 and 2 are admitted. 3 is admitted to the extent I previously stated.
Thank you, Your Honor. Your Honor, it appears that I will need to go in camera for a part of my cross-examination related to the Rolls-Royce CX Exhibit 1. Could we go off the record just to discuss the logistics of that? Because not all of my questions are directly related to that, and I would just like some guidance from council as to who should be in the room and not, and also what your preference is as to the scope of those questions that aren't direct to the confidential cross-examination exhibit.
All right, we'll go off the record this time.
Did I provide a copy? I have not seen it. I apologize. I meant to provide a copy. Let me go ahead and do that. And this will be Rolls-Royce Cross-Examination Exhibit 1C. The court reporter has marked, Your Honor, the document as confidential. But obviously, I didn't know until today what it would contain. And I believe counsel indicated that only the OUCC could have it. So I'm pausing to let them give me feedback on who, in terms of counsel and audience.
So, Your Honor, I'll respond here. This seems to me to involve economic development type offer, whether rate or otherwise, to a customer, either existing or potential. I think it is the only parties in the room that would be privy to seeing this would be obviously the petitioner, the party that received it, in this instance, appears to be Rolls-Royce. This is the first time I'm looking at this, so I'm just trying to respond quickly, and the OUCC. I think every other party would need to exit the room for this communications. I would also just exert now that I would say this is probably getting outside of what we're trying to do here in this proceeding. So Duke, I think, Duke would want to exert that concern right now, not only for purposes of efficiency, but also just the subject matter that's at issue in this case.
All right, I tell you what, Mr. Wells, why don't you and your team take a look at Rolls-Royce, the exhibit that they've just been handed. I'll do the same, and then we'll go around the room for objections and such. One moment.
Thank you, Your Honor. Your Honor, oh, sorry.
All right, Mr. Wills, have you had an opportunity to review that?
Yes, I have, Your Honor. I don't
Before we get into, I'm sorry, go ahead.
Oh,
I'll
no,
hear you out.
You go ahead.
So I think procedurally what we need to do, right now, nothing's been offered. Ms. Wheeler, you need to lay your foundation, as you indicated. I would just ask you, as I'm sure you would anyway, just to be cognizant of what information is being solicited in your questioning to ensure that what should be in camera remains in camera. And with that,
Can I just, this is I would say this is highly confidential as we've treated other.
I would take that at his word. I haven't studied it, honestly, to know that specifically.
Sure, thank you for that clarification. So you're aware in Mr. White's testimony that he is talking about a hypersonic aircraft engines, right?
Testing facility.
Well, the engines that Rolls-Royce will be building and testing are hypersonic engines. Are you aware of that?
Understanding, yes.
And a hypersonic engine for non-engineers like you and me is basically one that moves the aircraft faster than the speed of sound. Is that your understanding?
Sounds reasonable.
Thank you. Hyper meaning fast, sonic meaning sound. I remember a few things from grade school. So are you also aware that this is essentially an on-the-ground test center for those hypersonic engines?
That's my understanding.
Can we agree to an acronym of HGTC for a hypersonic ground test center?
Sure.
Thank you. Your Honor, I would ask that we go in camera and the court reporter put in front of Mr. Pinniger what's been marked for identification purposes as Rolls-Royce CX-1HC for highly confidential.
this time we'll go in camera. Parties that are not privileged to this information are asked to exit the hearing room. We'll call you back in once the in-camera portion of testimony has concluded, and with that, we'll stop streaming the live video. right, now Ms. Wheeler.
Thank you, Your Honor. I know it's been a very long day, Mr. Pinniger. I just have one question for you, and it's very general in nature. If Rolls-Royce wanted to speak with the Duke team about the potential for a special contract at the Purdue Research Park for its aerospace engine testing operations, would Duke be open to that conversation?
Well, Ms. Wheeler, as I've said at least 2 or 3 times with respect to some other matters today, we're always willing to talk. Again, our rates experts, I would imagine that the Rolls-Royce scenario has been built into some planning with respect to their load and how that equates to the equation of the case. So I'm not familiar enough to know how that has transpired up to now. And so we're happy to speak to customers.
Thank you, Your Honor. I have no further questions for this witness.
Thank you, Ms. Wheeler. Mr. Smith, any other cross on behalf of Sierra Club? We'll go off the record while Ms. Smith grabs a seat.
Your Honor, I have a question while we're off.
Yes, Ms. Becker.
Was there a highly confidential exhibit admitted into the record while we were in camera?
No.
Okay, thank you.
Yes. All right, Mr. Smith, are you ready? Not trying to hurry you. Oh, not yet. Go ahead, take your time.
If I could have one moment to get situated here.
Sure, take your time.
I'm ready, Your Honor. Thank you.
Okay, let's go back on the record. Mr. Smith, when you're ready, please conduct your cross-examination.
Thank you, Your Honor. Joshua Smith on behalf of Sierra Club. Good afternoon, Mr. Pinniger.
Mr. Smith.
Nice to see you. Nice to meet you.
Thank you. You also.
Mr. Smith, just be sure you're speaking directly into the microphone, please. Thank you.
Thank you for the reminder. Is that better?
Yes.
Okay.
Yes, thank you.
Earlier this afternoon, Mr. Pinniger, we spent some time talking about Duke's commitments to the 5 pillars. Do you recall that?
Yes, sir.
Affordability, reliability, resiliency, environmental sustainability, and stability. And within those parameters, wouldn't you agree that all options to provide affordable, reliable, environmentally compliant service to your customers should be on the table?
I do. All 5 pillars, as I mentioned earlier, I think carry equal weight.
And options that save customers money should always be consideration for the company, right?
Yes.
And it'd be fair to say you'd expect various departments within the company to be evaluating those options on a continuous basis. Is that right?
We do.
And in your rebuttal testimony in particular, you actually say at page 22, lines 3 to 4 of your rebuttal.
Which line, sir? Sorry, Mr. Smith.
Lines 3 and 4.
Yes, sir.
And just reiterating, you state Duke Energy in Indiana continuously reviews and evaluates its investment plans to ensure they are necessary and cost-effective. Is that accurate?
Yes.
You mentioned earlier that you're also familiar with the intervener testimonies in this case. Is that correct?
Generally, yes.
Yep. And then you're also, of course, familiar then with Mr. Luke and Mr. Suez's testimony.
Very.
Mm-hmm. And in particular, the rebuttal testimonies that go to intervener issues related to Edwardsport, Gibson, and Cayuga in particular.
Yes, sir.
And more specifically, Mr. Luke and Mr. Suez address some of the parties' concerns about Edwardsport in particular. Are you familiar with that?
Yes.
And several parties have recommended, urged the company to convert that unit to burning only natural gas instead of syngas. Is that correct?
That's correct.
And you're pretty familiar with this issue because it's come up a couple of times, including in the last rate case. Is that right?
It did, yes.
And in
Same
that
parties.
Same parties, and that includes the industrial companies. Is that right?
Industrial group?
The industrial group.
Yes, sir.
And it includes the environmental groups. Is that correct?
In 24, currently, yes.
Yes. Thank you. Now, are you familiar with Mr. Cummings' testimony on behalf of Sierra Club?
I am not, no.
Okay. But you are familiar with Mr. Suez's and Mr. Luke's testimony that address some of the concerns that Mr. Cummings raised?
I did read those, yes.
And Mr. Cummings in particular, like some of the other parties, recommends a conversion at Edwardsport. Are you aware of that?
I would believe that, yes.
And part of that, and part of the recommendation, part of the basis for these recommendations stems from the company's integrated resource plan. Is that correct?
From the interveners or from the standpoint of Mr. Luke and Mr. Suez?
From the intervener's standpoint.
That would make sense to me.
Okay. And are you aware that the company's 2021 IRP recommended or found that in several circumstances that converting Edwardsport to burn only natural gas was cost optimal?
Well, I don't remember exactly how it was phrased. I do know that there was a lot of discussion around the cost of the gasifiers, in addition to many other elements around the attributes of Edwardsport.
Okay. And let me just pause for a moment to make sure that, or ask you what your understanding of how the IRP process works at a very high level, if you don't mind.
Well, it's complicated.
Yeah. And so you can keep it very high if you'd like. I'm just kind of.
Well, we have a team of IRP experts that do a heck of a lot of modeling, our own modeling, our stakeholders' requests for different portfolios and the modeling associated with those. We run those models through various stress tests. We hold a number of stakeholder meetings throughout the year, which we're doing now, as you're aware. We produce a menu of criteria that we gauge the various portfolios against, and ultimately we come up with a preferred portfolio that we put before the stakeholders, but not without a lot of engagement by those stakeholders along the way.
Okay. At a very basic level, and maybe superficially, you would agree that the basic idea behind a resource plan is to identify what is the least cost reliable portfolio that can serve customer need.
Well, I think those are two of the attributes, yes.
Okay. And there are a number of different assumptions, economic assumptions and otherwise, that go into that modeling, right? Such as gas prices, for example.
Yes.
Environmental compliance risks going forward, correct?
I believe that's correct, yes.
Operations and maintenance costs at any particular unit, correct?
Yes.
Anticipated capital costs and things of that nature, is that correct?
Yes.
And you would expect that your expert team of IRP analysts use reasonable data, right?
Absolutely.
And reliable assumptions, would you expect that?
I believe that to be the case, yes.
Okay, thank you. I want to talk just a little bit about the 2024 IRP process that you alluded to that's going on right now. Are you aware that in that process, with the implementation of what's called the 111D rule, Edwardsport converts to gas in 2030, according to the model, under every scenario?
Well, I knew that obviously under 111, it was going to have to convert in the 111 path. Of course, we're doing two different paths, a 111 and a non-111 path. So it makes sense to me that under a 111 path, it would convert to gas earlier.
And that's because under 111D, if Edwardsport converts to gas before 2030, it can avoid additional carbon costs. Is that correct?
Additional carbon costs, such as sequestration or?
Exactly.
Well, I don't know all the criteria that's gone into, frankly, into that specific date, but I am familiar with the 111 rule and some of the restrictions or alternatives that are required for further operations.
Edwardsport's current expected retirement date is 2045, is that correct?
Whether on syngas or gas?
That's just the company's anticipated end-of-life date as it stands.
I believe it's 2035.
2035?
Well, it may be 2045, maybe 2035.
Okay. Are you aware that if it operates on syngas until 2045, it would be required to install carbon capture and sequestration technology?
Under 111?
Mm-hmm. Yes.
That would make sense to me.
That'd be a pretty significant investment, correct?
Well, we have a witness, as you are aware, that is going to talk about CCUS. It's an interesting topic. I know it's not well liked by everyone in this room, but there are significant tax credits that can make potentially project more affordable.
Okay. Some of the other driving factors for an earlier an earlier conversion date, and in particular a 2030 date under the IRP modeling, would be the cost of continuing to operate the plant. Isn't that right?
I don't know if that's specific to 111 requirements or
ordinary operations and maintenance. Let's start with that.
Well, my understanding is currently the gasifiers would operate until at least 2035.
I guess let me try to phrase this a different way. Are you aware that the operation and maintenance costs at Edwardsport, let's say for the test year, for example, are quite a bit higher than a traditional coal plant?
I am.
And they're quite a bit higher than gas-fired generation units. Is that correct, too? And the same goes for capital investment in the test year. It's quite a bit higher than you'd expect at a traditional coal plant. Is that correct?
Well, it depends. The coal units, I can't answer that.
Okay. Are you aware that some of the costs associated with O&M and upkeep of the plant, as well as capital costs associated with the operation of the gasifiers at Edwardsport?
With specific figures? Is that what you're asking?
Just as a general matter, are you aware that those gasifiers, the gasifier trains, are a driver of pretty significant costs at the plant?
I am.
And in particular, those gasifiers, if you take them offline, it costs quite a bit of money to get them back online. Is that correct?
Well, Mr. Luke goes into quite a bit of detail of not only the cost of getting them back online, but the cost associated with, just personnel, loss of some load, the attributes that the plant brings with its flexibility. So he goes into quite a bit of detail with various factors and criteria around making that decision.
And let me be even more specific. There was as part of this case, Mr. Suez talks about a major outage at Edwardsport that that costs about $50 million associated with the gas fires. Are you aware of that?
Mr. Luke?
Mr. Luke, I'm sorry. Thank you for the correction.
Yeah, he did, and he talked about that cost scenario in some detail in his rebuttal.
Right. And the company assumes that that major outage, those major investments in the gas fires are going to occur approximately every 7 years.
That's my understanding.
Is that correct? So do you expect those to be, again, in about 2027?
I think you'd be better asking Mr. Luke exact dates.
Okay. If the Edwardsport plant did convert to gas, burning only natural gas rather than syngas, presumably you could avoid any major outage associated with the gas fires. Is that right?
If the gas fires aren't there?
Yep.
I think that's right.
Yeah. Thanks. Yeah. So appreciate that. So in response to a number of these concerns that Mr. Cummings and other parties raised and the things we've talked about here, Mr. Luke states, are you aware that switching Edwardsport to burn only natural gas would require additional study? Are you aware of that?
I don't remember that specific phrase.
But do you think it would require additional study to decide whether, in light of these costs and these risks, it makes sense to convert the unit to burn natural gas?
It seems to me many of the criteria that you and I spoke about with respect to the IRP do that.
And but Mr. Luke's testimony gets to the technical capability, the engineering side of converting the unit to burn natural gas, right?
Well, again, I don't remember that particular phrase that he refers to. Maybe Mr. Luke would be better to answer to his language.
But in any case, you would agree, right, that it would be reasonable to study and take a close look at converting Edwardsport to natural gas, wouldn't you?
Well, again, the IRP is a vibrant process. You all have been a part of that this year. I hope you've been happy with the process. Happier, anyway. You know, as I look at Edwardsport personally, and Mr. Luke and Mr. Suez are much more detailed with respect to not only the operations, the cost, and the dispatch of the plant, their areas of expertise. I still see a very young plant. I still see a plant that provides considerable attributes, particularly in this time of uncertainty. We don't know yet if we have a 111 rule to comply with or not. It is currently, as I understand it, subject to a stay evaluation by the U.S. Supreme Court. We have MISO changing accreditation rules on us fairly regularly, planning reserve margins, dispatch models that MISO is expecting of us or will be penalized for our units. And I understand all that, right? We just went through a week of hot weather, and I'm happy to say that Edwardsport and all 33 of our plants operated very well. We needed them. So I think given those criteria, and I couldn't help myself based on your first question about a similar discussion we had in 2019 and 2020, I recently read page 96 of the order in which the commission expressed their support for the plant, recognizing those attributes that I just spoke about. So I think that the IRP process is playing itself out. I think there's a lot of uncertainty right now with respect to capacity needs and energy needs in Indiana and in the Midwest in the MISO system. And I think that Mr. Luke and Mr. Suez do a marvelous job in operating and dispatching that plant. It does provide flexibility that we have taken advantage of. In fact, recently, we talked about some of the issues with respect to price that Duke Energy Indiana experienced coming out of the pandemic. It was because we could not get coal deliveries. And so in part of that time, we were able to transition effectively the Edwardsport portion of the Edwardsport plant to gas and have those coal deliveries made to Cayuga, which was beneficial. So the flexibility is, I think, hugely important in this time of uncertainty as well.
Thanks for that. I want to try to unpack that a little bit, because
Sure.
try to take it piece by piece, because you mentioned a lot of different factors there. I think they're all important. But you mentioned understanding the economics of the plant, I think, correct? That's an important factor, isn't it?
It is a factor, yes, important.
Understanding sort of unit-specific cost and engineering aspects of converting the unit, correct? That's something you'd want to know in evaluating whether to convert the unit to gas?
I think what I was trying to express, at least in that last little diatribe I had, was I think it's too early to do that.
It's too early to even study it?
Well, I think we are studying it in the context of the IRP at the very least.
I just want to try to flesh out what the study might look like. And so we're in the IRP process, looking at reliability, looking at, right, reliability is one of them, correct?
Mm-hmm.
Looking at what MISO's needs are in terms of capacity, correct?
Yes, sir.
The new capacity construct. Looking at the economics of the facility, correct?
Yes,
Looking at environmental risks coming down the pike, correct?
I believe that's correct.
I believe you mentioned fuel diversity,
Yes, sir, I did. I was going to say it if you didn't.
right? And how do you get fuel? How do you get fuel to the unit? What kind of fuel that might be? Is that another factor you'd want to look into?
I think the flexibility, we have access to both, obviously, coal and gas at the plant.
And so this whole constellation of issues, I'll come back to the initial questions. Don't you think it would be reasonable to evaluate that whole constellation of issues in determining what the future is of Edwardsport?
Well, I believe that the IRP process is doing that. I mentioned in my earlier discussion of the IRP, not only all the engagement, but the development of a list of criteria that we are evaluating these portfolios against. And they may have different words involved, but many of the attributes that you just mentioned, I think, are part of that evaluation.
Right. Are you aware that Mr. Luke has described these different factors, and in particular the IRP cost assumptions, as what he's described as planning level assumptions versus rate case quality assumptions? Do you recall that from his rebuttal testimony?
I don't, I'm sorry.
Do you think that there would be any value in getting more granular understanding of the options between converting and continuing to run on syngas?
Not at this point.
You don't think it would
outside the IRP and a continued evaluation of the value, and certainly watching what will happen with EPA Rule 111 here in the near term.
So in the face of, let me just see if I can capture what you're saying, in the face of information from the IRP process that you described.
Yes, sir.
You described as using reasonable inputs and reliable inputs.
I believe so.
And in the face of environmental risk in the form of 111D, and in the face of...
We don't know if it's a risk.
It is a final rule, though, isn't that correct?
It is, yes, absolutely.
And it's not currently stayed, is that correct?
That's correct.
And in the face of information about O&M and capital costs at Edwardsport exceeding other generation sources, you don't think it would be reasonable or necessary to evaluate converting the unit to gas?
Not at this point in time.
Okay. Thanks, Your Honor. I don't have any more questions.
Thank you, Mr. Smith. Mr. Miller with Steel Dynamics is not present, nor is Ms. Zacola with Wabash Valley Power Association. Mr. Nam with Walmart, do you have any cross?
Yes, I do, Your Honor. Hopefully very briefly.
Very well.
Good afternoon, Mr.
Seems
Pinniger.
like morning.
Yeah, Barry Nam from Walmart. It seems like some morning anyway. Speaking of which, this morning when I said hello to you, I said, good to meet you, but I realized we've already met, so I apologize for that. I had informed your counsel this morning that I did, in fact, have some questions for you this morning, some discrete questions. But over the course of the hearing today and the conversations you've had with other counsel, I wanted to just pursue a line of questioning as a follow-up to some of those questions, specifically related to the pillar of affordability. On page 22 of your rebuttal testimony, sir, you actually do address Walmart witness Ms. Perry's concerns about the impact of the rate increase on business customers. You would agree that this is the statement of affordability that you were referencing in response to Ms. Perry's testimony. Is that correct?
I was reading what I provided with respect to Walmart, and I have to respectfully ask you to ask the question again as I was.
Let me do that. Did you read all of Ms. Perry's testimony?
I don't believe so.
You do not? Can we go off the record?
Certainly.
I'm just
Go off the record.
a copy of Lisa Perry's testimony.
All right, we'll go back on the record.
Thank you, Your Honor. I've handed the witness Walmart Exhibit 1, which has been admitted to the record. If you could turn to page 8 of Walmart Exhibit 1, sir. Ms. Perry discusses specifically the company's proposed return on equity in this proceeding. And do you see at line 13 that she notes the customer impact of the resulting revenue requirement increase from that ROE as one of her concerns?
I do.
Okay, thank you. Would you agree that Ms. Perry presented evidence in this case through Walmart Exhibit 1 regarding the difference in the company's requested 10.5% ROE and the company's current 9.7% ROE? And I can direct you to page 11 of Walmart Exhibit 1.
She's making that distinction? Is that what you're asking me to verify?
Yes, she's noting the dollar impact of the difference between your current ROE and a 10.5 ROE. Do you see that? Page 11, lines 10 through 12.
I see that.
Okay, do you have any reason to dispute Ms. Perry's calculation of that $53.7 million difference between the company's requested ROE and the current ROE?
Well, subject to check, I wouldn't dispute it.
Okay. So $53.7 million, representing the difference alone between the company's requested ROE and your current ROE. Mr. Pinniger, would you agree that that poses an affordability issue for customers?
Well, again, are you talking about the 5-pillar analysis with respect to affordability?
Yes, to customers, sir.
Yeah. Well, so I've talked a lot today about how I view the 5 pillars. I could never sit here and try to take the place of Mr. McKenzie or Mr. Bauer. I think Mr. McKenzie will be on the stand to discuss his work around the ROE, but I can't emphasize enough the importance of an effective ROE for a public utility. You all are aware of that. We have to appeal to debt and equity investors for the capital that we are responsible for raising for our customers and to deploy capital for the projects that the 5 pillars represent, as well as other customer expectations. And so, the healthier the utility is from a financial standpoint, from the perception of those debt and equity investors, the cheaper the capital will be that we deploy.
You would recognize that at least one customer, Walmart specifically, has identified that $53.7 million as a concern regarding the company's proposal. Fair enough?
I see that absolutely in her testimony.
Earlier today, I think it was this morning, on questions with Ms. Washburn, she had asked you a question about a proposed ROE at 9.0%, and you had indicated that that would place the company in dire straits. Is that your testimony?
I believe so, yes.
Okay. Mr. Pinniger, at your current ROE of 9.7%, is Duke able to provide reasonably adequate service to its customers?
We have, but that ignores the statement I just made about the responsibility that we're given to effectively and reasonably, at the lowest cost possible, raise capital through those channels on behalf of our customers. And I would also say, and this is embedded in my testimony many times and rebuttal, I view the utility as a high-performing utility. Our metrics bear that out. Customer sentiment bears that out. Our reliability factors have improved immensely. And I think storm recovery, our external engagement, I think, shows the elements of a high-performing utility.
So Duke is not currently in dire straits despite the 9.7% ROE?
Well, talking about Duke Energy Indiana?
Yes.
You know, every year is different, quite honestly, from a revenue standpoint. Volumes, weather, reconciliations. I talked a little bit earlier about the 2022 impact of a $432 million impairment. So each year is different.
You confirmed earlier today that shareholders are still getting paid even at a 9.7% ROE. Those dividends are still being paid?
They're earning a dividend, yes.
Great, thank you. So do any parties in this case support Duke's request for a 10.5% ROE?
The petitioner.
No other parties, no intervening parties?
I haven't seen that, no.
Thank you. Good clarification, though. Appreciate that. So the commission in this case is tasked with balancing a couple of arguments and a couple of interests. On the one hand, Duke is claiming dire straits, and apologies for the Gen X reference, but on the other hand, the consumer parties that are claiming that 10.5 is money for nothing. Would you agree with that?
I was responding to an ROE at 9.0.
Right.
Yes, sir.
Right. Dire straits at 9.0. Consumer parties, money for nothing at 10.5%. Is that a generally fair characterization of?
Seems to be the sentiment.
The balance that the commission has to do in this case?
Yes, sir.
Correct. Today, also, you, on some questions with, I believe, Ms. Washburn again, you had noted that Duke Energy Indiana is very competitive in comparison with its neighboring utilities. Do you recall that conversation?
I do.
Would you agree that in terms of ROE, Duke Energy Indiana is presently very competitive in comparison with its neighboring Indiana utilities?
It doesn't seem, it may be a matter of basis points, but it doesn't seem that we are in the same ballpark as of recently with our Indiana peer utilities.
But you do believe, don't you, Mr. Pinniger, that comparison with neighboring Indiana utilities provides a valuable benchmark for the commission?
With respect to ROE?
Sure.
I think each story is different.
Okay.
I talked about the performance of the utility, which in this case of Duke Energy Indiana, I'm very proud of and I think should be considered in that respect.
Are you aware that Walmart Witness Perry did an analysis of the four most recent orders from this commission with stated ROEs? Do you recall that from her testimony?
I don't.
If you look at page 9 of her testimony.
Mr. Nam, I just note while the witness is looking that up that we're 10 minutes to 5 o'clock, which was our stated stop time.
Yes, sir.
He's playing accordingly. Thank you.
Finish very, very soon. Thank you.
Which 9?
Page 9 of
Yes, sir.
Walmart Exhibit 1. And you see it lines 9 and 10. Since 2001, the commission has issued orders with stated ROEs in 4 cases, and the average of those ROEs is 9.75%.
Well, it's the first time I've seen that, but a lot's happened since 2021.
Yeah, but do you have any reason to dispute that evidence?
Her calculation?
Yes.
No.
Okay. Thank you. That's all for that line of questions. The last one is just very briefly on the original question I wanted to ask you. On page 22, again, of your rebuttal, line 13.
Second, sir.
Oh, sure. Sorry.
Okay.
Line 13, you state Duke Energy also offers programs and services tailored to the needs of its business customers. And this is in reference with helping those business customers manage their energy costs effectively, as you state there on line 15. It's not directly related to that, but I would just like to know, Mr. Pinniger, as the president of Duke Energy Indiana, do you think it's important for Duke to provide services and programs that meet business customers' needs, generally speaking?
I do.
Okay. Are you aware then, and if you look at Walmart Exhibit 1, page 25, are you aware that in this case, Walmart raised an issue regarding electric vehicle rate structure?
I'll take you at your word.
Okay. And specifically, Ms. Perry recommended that, that Duke Energy work with customers. She refers to them as third-party owned public-facing EV charging customers, to work with those customers to develop a specific EV rate that would accommodate their business plans. Would you accept that?
Well, Mr. Flick, who will be on the stand soon, not today, but soon, has developed an aggressive time of use, voluntary time of use.
But it's not a specific EV rate for these third-party owned public-facing chargers, is it?
That's my understanding. Correct. You're correct.
That it's not?
You'll have to ask Mr. Flick.
Okay, sure. Earlier in your rebuttal, and again, not related to EV, but you discuss ongoing collaboration. Correct me if I'm wrong, but I assume that as president of Duke, you view ongoing collaboration with stakeholders to be an important function of the utilities business?
Absolutely.
Would you have any objection as president of Duke Energy Indiana to having a collaboration with third-party owned public-facing chargers to hear what their concerns might be regarding a potential rate?
May I clarify what is a third party?
Okay, I was hoping you would do that. So third party, when we talk about the EV rates, you've got the utility is one party.
Yes, sir.
You've got the EV driver, which is another. And then there's businesses such as Walmart that operate charging facilities at their sites. So Walmart would be the third-party owned charging station, those charging stations.
I get it.
Does that
Thank
make
you.
sense to you?
Yes, sir.
Would you have any objection as?
No objection.
Okay, great, thank you. That's all the questions I have.
Thank you, Mr. Nam. Mr. Rampala, when earlier this morning you indicated that you were reserving the opportunity to conduct cross of Mr. Pinniger. Does Block have any cross?
Thank you for remembering, Your Honor, and other than to say that along with Mr. Nam, I'd like my money for nothing and my checks for free, I do not have any cross at this time.
All right, very well. Thank you, Mr. Rampala. This hearing is continued to tomorrow morning, August 30th at 9 a.m. Thank you, counsel. Hold on. Let's go back on the record if we're not off. Okay, we're on the record. I assume that Duke is going to have redirect. Is that correct? I should have asked. Okay, with that, in that case, Mr. Pinniger is excused. Thank you. And with that, we'll go off the record.